This hearing is in the matter of CFI 099-2021 before Justice Wayne Martin and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimant is represented by Seoul International. Lead counsel is Sarah Malik. The defendants are represented by Al-Tamimi and Company. Lead counsel is Tom Montague Smith, QC.
Good, thank you. Mr. Montague Smith.
Thank you, Your Honour. I don't know whether Your Honour's had a chance to see the skeleton arguments. You will have seen I'm here on behalf of, I'm grateful, I'm here on behalf of the defendants, and you have Miss Malik is here for the claimant, and this is my application disputing jurisdiction.
Counsel, you can assume that I've read the principal documents. If there are any particular passages in particular documents that you want to emphasise, then you should take me to those. But I'm across the issues and the principal documents, if that assists.
That's very helpful. Thank you very much. And as ever, do please intervene to either move me along or slow me down as usual.
You will know well enough by now, Mr. Montague Smith. I need no encouragement to do that.
All right. Well, I'll leave that there.
So you seem to have frozen. Whoops, I lost.
Have I frozen?
Oh, yes.
Sorry, I just dropped out.
That's all right. Just let me know when you're back on.
Yes, I'm back on business. Back to you, Mr. Montague Smith.
Great stuff. Thank you. All right. So Your Honour will have seen that there are three principal grounds that we advance in relation to this application, and the main one.
Hi, just give me one moment because.
Sorry, Rita, could you mute yourself? Thank you. After that, so the principal ground is the exclusive jurisdiction agreement in favour of the Beirut courts. You'll have seen my learned friend says it's not exclusive. I say it plainly and obviously is exclusive, and I'll have to show you a couple of authorities in relation to that. And what she also says is that even if it is an exclusive jurisdiction agreement, you can ignore it for various reasons, which have to do with the state of the Beirut courts and certain aspects of what I would describe as Beirut law arising out of the change in exchange rates. So that's the sort of centre of what I'm going to be discussing. There are two other points that I'm going to emphasise as well. The first is the question of underlying jurisdiction, which my learned friend puts in terms of Article 5A(1)(b) on the basis she says that the relevant contract was in part concluded in the DIFC. And that's about, she says, the result of negotiations taking place in the DIFC. But that's a separate point, and she has to win on both of those points, because if there's an exclusive jurisdiction agreement and you enforce it, I'm going to just admit that person. If there's an exclusive jurisdiction and it needs to be enforced, then it doesn't matter whether there's underlying jurisdiction. If there isn't an exclusive jurisdiction in favour of the Beirut courts, or it isn't to be enforced, there still needs to be underlying jurisdiction. So I will look at that. I'll deal with that quite briefly. And then the third point, which is also a short point, is the question of whether the proceedings have been properly served in Beirut, and we say they haven't against either of the defendants. That is the shape of what I'm going to be discussing, but I'm going to focus my submissions on the first ground, which is the exclusive jurisdiction agreement. Let me just show you that, if I may. It's in the contract, and it's at bundle A, tab 4. It's the first document, page 12.
Moment. Oh dear. Sorry, Mr. Montague Smith, I've been having technical trouble all day. And it's persisting. Oh dear. Yes. Go.
So if your honour has that, just let me know when you've got them.
I have it. Thank you. I've got it now. Thank you.
Thank you. And the relevant part.
Yes.
The relevant part is simply that on page 18, it's the jurisdiction agreement in that contract, and it's clause 18.2.
Yes.
And you will see that it reads, when you get there, all disputes that may arise between the parties hereto related to the implementation and execution of this agreement. And then these are the important words: shall be referred to and settled by the courts in Beirut, Lebanon.
Well, now, Mr. Montague-Smith, you'll come, I suppose. I can either do it now or come to it when you wish. There's evidence of negotiations that included an earlier version of the agreement, which contained a quite explicit exclusive jurisdiction clause in favour of the DIFC courts. Now, do you say that that's admissible as an aid to the? Do you say that's relevant and admissible as an aid to the construction of this clause? In other words, that the fact that there was a prior version which explicitly used the word exclusive, and this agreement which doesn't, is that something I could take into account or not?
Well, I mean, it depends. If you're approaching the principles as a matter of DIFC law, then in principle you can look at the negotiation of the agreement. But what I say is that actually what you have to do is just interpret the language that you're faced with, and you'll see from all the authorities that the critical question is whether or not there is an obligation to bring the proceedings in the Beirut courts. Is other parties obliged to do it? And you'll see multiple cases which deal with the word shall. I'll take you through that in due course. The question of what and then also you will see multiple authorities that make it clear that the word exclusive is not a necessary part of an exclusive jurisdiction agreement. That has been said over and over again. That is to surrender to formalism, and that is not what your honour's about. Now, the question of the language of the prior court of the prior agreement, we say is just irrelevant because it cuts both ways, doesn't it? Either it shows that the parties were always contemplating an exclusive jurisdiction agreement somewhere, or my learned friend would say, well, actually, the change from the wording from exclusive to something else shows that they were trying not to be exclusive. But fundamentally, what it comes down to is the language. Shall, you shall. I'll take you to the authorities on that. But you've got the responses and just I should just to clear it up. There's no dispute that this claim comes within the terms of this clause. So it is a dispute which relates to the implementation execution of the agreement. So the only question is, firstly, is it an exclusive jurisdiction agreement? And secondly, if it is, should you nevertheless allow this claim to proceed, exercising the discretion that the Court of Appeal in Karafi says you have? And in principle, we do say that even after this, there is a forum non-convenience point, and that Beirut is clearly and distinctly the more convenient forum. But we don't go into that in any particular detail because the clause is very clear. We say it's plainly and obviously an exclusive agreement. So what we've done is set out a bit of authority on this in our skeleton argument, but I was going to just take you actually, I think, to the leading textbook on the issue, because this is not this pretty well trodden ground, the construction of jurisdiction agreements and the distinction between exclusive and non-exclusive ones.
Sorry, Mr. Montague-Smith, I dropped out again. I've changed my connections at this end in the hope that that'll stop happening. But I wonder if you could just repeat what you said over about the last minute or so.
Yeah, sure. All right. So I was just saying that the two issues on this aspect of the application that you need to deal with are, number one, is this an exclusive jurisdiction agreement? And number two, if it is, should you enforce it? Or in other words, or rather the burden's on my learned friend at that point. Are there strong reasons not to enforce that agreement? I was just telling Your Honour that we do say that in this case there's a forum non-convenience point to be made. So we do say that Beirut is clearly and distinctly the more convenient forum, and we set that out in the application. But we say the first point on this, the exclusiveness, the exclusivity of this clause, is so clear on the face of the agreement that we don't go into extensive detail about that. We say this is as plain as day an exclusive jurisdiction agreement. The only way that it could be more clear is if it had the word exclusive in it, but that is not, as I say, on the authorities a necessary thing for it to be exclusive. In terms of authority, I was going to then take you just to the text, the leading text on this, which is Joseph, the Enforcement of Arbitration and Jurisdiction Agreements. It's because this is really well-trodden ground. There's nothing particularly novel about deciding whether or not an agreement is exclusive or non-exclusive. And there are many harder cases than this one. But if I can just take you briefly to section G of the authorities bundle and to tab 14, please.
Yes. There.
And if you have page 1098.
1098. Yes, I have it. Thank you.
Thank you. And it's paragraph 4.04
Yes.
is where I'd just like to start. And I'm just going to show you three short passages of this text, which is all about the enforcement of jurisdiction arbitration agreements by one of the leading practitioners. So 404, an exclusive jurisdiction agreement gives rise to the mutual right and obligation to refer disputes that fall within the scope of the clause to the identified court. That's an exclusive one. So the mutual right and obligation. This is to be contrasted with a non-exclusive jurisdiction agreement, which is an agreement by one or more contracting parties to submit to the jurisdiction of one or more identified courts. A non-exclusive agreement, jurisdiction agreement, does not create a contractual obligation to bring proceedings in the identified court or courts. So that's the distinction. And then just carrying on down to page 1102, please, and paragraph 4.11.
Yes.
In each case, the courts will construe the contract and look for words giving rise to a transitive obligation. In other words, the positive obligation to refer disputes as opposed to the intransitive obligation of a party to consent or submit to the jurisdiction. So that this can sometimes be inferred by the use of the expression shall. It is not necessary for the parties to use the expression exclusive jurisdiction. This would amount to an inappropriate surrender to formalism. And then the next paragraph is 4.12, where parties agree to submit disputes to an identified court or submit disputes to the jurisdiction of such a court, then as a matter of construction, an English court is likely to conclude that an exclusive jurisdiction agreement has been effected. And you'll see at footnote 35 some examples. And I rather than bombard you with cases, these just give a flavour of the sorts of circumstances that have given rise to construction that the agreement is exclusive. So you'll see standard chartered owners protection and indemnity insurance. Parties expressly agree to submit. That was a transitive obligation and therefore an exclusive jurisdiction agreement. The British Aerospace case, the parties hereby agree that the English courts shall have jurisdiction to entertain any action. That was an exclusive jurisdiction agreement. The customer irrevocably submits to the jurisdiction of the English courts. It was also an exclusive jurisdiction agreement. So the courts are not shy to say, well, if the parties are making this agreement, then if you bring your claim in another case, would that be a breach of this agreement? They shall submit. They shall agree to submit. Then or the English courts shall have jurisdiction. Then even in those circumstances, the courts have said, well, if you bring your claim in another jurisdiction, you're frustrating that agreement. But as we've already seen, the expression shall is usually going to be sufficient, but it's not actually necessary even to have that. The point that the word exclusive is not required, that would amount to inappropriate formalism, that comes from a case called Continental Bank, which we have included in the authorities bundle. And if you'd like to look at it, we can show you it. It's in the same bundle, G tab 3 at page 899, but the relevant passage is at 904.
Let me find that.
And the passage is page 904 of the bundle, page 593 of the report, and it's down at H, little big capital H at the bottom. Does clause 21.02 contain an exclusive jurisdiction clause? Clause 21.02 does not expressly make clear that the jurisdiction agreement is an exclusive one, and then says Dicey submits that the question is simply whether on its true construction the clause obliges the party to resort to the relevant jurisdiction, irrespective of whether the word exclusive is used. It refers to a case called Sohio Supply. The Court of Appeal approved this submission as contained in Dicey and Morris. In our judgment, it would be a surrender to formalism to require a jurisdiction clause to provide in express terms that the chosen court is to be the exclusive forum. Now, overnight, or this morning, my learned friend has provided us with a passage from Dicey as well. I don't know whether Your Honour has that. It's
No,
separate. I'm sorry?
I haven't seen that, I don't think.
Well, I think my learned friend's going to want to take you to it. And so perhaps what I'll do is I'll save that bit for reply. But ultimately, yes, Dicey says precisely the same thing. It says the question is whether or not there's an obligation. So here, if we go back to our clause, which is 18.2, the relevant words are all disputes shall be referred to and settled by the courts in Beirut. So there's an obligation. It's impossible to construe that clause, regardless of what happened in the run-up to it, as anything other than imposing an obligation on both parties to bring the dispute in the courts of Beirut. Now, my learned friend makes a number of points in relation to this. And one of the points that's made is set out in the particulars of claim, because rather unusually, these particulars contain quite a lot of argument about jurisdiction. And one of the things that is referred to is a decision by His Excellency Justice Ali Al-Madani. And I just want to show you what my learned friend says about this and then explain why it doesn't actually help. If I can show you the particulars of claim, you'll find them in Bundle B,
yes,
tab 5.
You got the page number in the
yes,
bundle?
Certainly. It's 680.
Thank you.
So we're in the particulars of claim.
Yes,
here.
I have that. Thank you.
Thank you. And it's paragraph 46, talking about the obligation to have specificity and clarity in relation to opt-in clauses. And what my learned friend says is, well, if you'll recall, the particular provision of the judicial authority law requires that any agreement to the DIFC courts be specific, clear and express. And what my learned friend is saying here is that all applies also to opt-out clauses and refers to a case called refers to a decision in Commercial Bank of Dubai.
Yes, sorry, I just dropped off the line again, but I'm familiar with this line of territory. I have to say I've never really understood what Sir Jeremy Cook's observation. Never really understood the practical impact of that observation myself. In other words,
yeah. Go ahead. Sorry, I interrupted.
If the clause properly construed is an opt-in, then I don't know what specific, clear and express adds to it, but anyway.
That's exactly what Sir Jeremy said in the case. That's precisely what he said. So what just to build the argument from my learned friend, what my learned friend is saying is, well, look, if you look at Commercial Bank of Dubai, Justice Ali Al-Madani was saying, look at Suntec. In Suntec, Mr. Justice Cook says it all has to be clear, specific, and express. But if you actually look at the case in Suntec, Sir Jeremy says precisely what you've just said. He said, if on a true construction that's what it means, then it is by definition clear, express, and all the rest. And I can show you that very briefly, if I may, just so you've got it. So in case it helps, it's at bundle G again, tab 10, and the page number is 1061. And it's paragraph 24 at the bottom.
Yes.
He says, at the end of the day, it would be nonsensical to conclude that the parties had agreed to the jurisdiction of the DIFC courts as opposed to the onshore courts, but that the words were not sufficiently clear, specific, clear, or expressed to amount to an agreement for the purposes of Article 5A2 of the amended Judicial Authority Law. Now you can skip down to the fourth line of the next page, please. What it is looking for is an agreement which is specific enough and sufficiently clearly expressed to amount to a choice of the DIFC courts. Whilst in an ideal world, the use of wording such as that set out in the practice direction would be employed, the courts do not live in an ideal world and have to construe the contracts in issue to determine the party's chosen jurisdiction when faced with clauses such as those found here. Once the clause has been construed, the court reaches its conclusion, which in itself means that the words used are specific enough, clear enough, and express enough for that conclusion to be reached. And it goes on just 3 lines down from there. If the parties have agreed to the jurisdiction of the DIFC courts on the proper construction of a jurisdiction clause, the agreement is ex hypothesi sufficiently specific, clear, and express. So he's saying precisely what you've just said. There's no discrete element of DIFC law which impacts on the construction of this agreement. That's the point. And you'll recall, yeah. And one of the other things that is said on behalf of the claimant is that the claimant asserts his own understanding, his own personal understanding of what was being agreed. He says, well, he thought that he was agreeing something that was non-exclusive. That is, of course, completely irrelevant on any view, on DIFC law, on English law, on any approach. It's not said that there was an express agreement of words, we will agree to this, and that the wrong thing was written down in the contract. There's no claim for rectification here, and there's no basis for any such claim for rectification. To the contrary, if you look, when I'm sure my learned friend will take you to his evidence, but if you actually look at what he says there was no mistake in recording the terms of what was agreed. So he doesn't contend that there was some error in transposing the agreement into the written document. And in those circumstances, what you are left with is the written document, and that is where the agreement was reached, because it was a document it was a contract that was agreed in writing. It's not a contract that was agreed between the parties and then transposed into writing. So in terms of that question, we lost the judge, I think.
I'm back again. I've had a message from my internet service provider saying they're trying to fix the problem, but that's a small comfort to you, I'm afraid. I do apologise for dropping in and out.
Not at all. I've been in exactly that position more than once, I know, in your court. So
yes, all right.
Understand.
Now I don't know if you recall, you were taking me through Sir Jeremy Cook's decision, and I think that's about when I dropped out. You just about finished that, I think, when I dropped out.
Oh, I see. All right. That was quite a while ago, so I've been talking to myself.
Yes, I'm afraid so.
That's all right. All right. So I think I did. So I'd taken you to the relevant passage, I think.
Yes.
And
Yes.
Justice Jeremy has said, if I can construe it as a DIFC jurisdiction agreement, then ex hypothesi, that was his words.
Yes.
In other words, it follows from, as a matter of logic, that it satisfies the test. So the point I was making there was simply to respond to my learned friend's argument that somehow there's a particular feature of DIFC law that it impacts on the construction. There isn't. It doesn't. At least that submission doesn't get anywhere. The other point that's raised, and I was going to move on to deal with very briefly, was the assertion by the claimant that his understanding of the agreement was that it was non-exclusive. So he provides evidence to say, well, this is what I thought I was agreeing to. And I'm just making the point that that, with respect, is wholly irrelevant. It doesn't matter what I think I'm agreeing to. What matters is what I actually agreed to. And of course, during the course of these negotiations, at the end anyway, both parties are represented by lawyers, but neither party's subjective intention and understandings of what's going on is going to affect the construction of this agreement. What matters.
And
Yes.
So you'd say the claimant's mistake as to where one of the officers was, that is, whether it was in the DISC or not in the DISC, is irrelevant.
Well, yes, but that's a different point. That's the question of underlying jurisdiction. So,
Yes.
yeah, so that's the question of where the contract was entered into. And of course, that is correct, because that's just a straightforward. It doesn't. The test is not where do the parties think they're contracting. The test is where are they contracting, if that's the issue there. But in terms of actually, this is about whether or not this is exclusive or non-exclusive. And one of the points that he's making is he said, well, I thought I was agreeing to a non-exclusive agreement. I thought that was what the effect of the contract was. Well, that's irrelevant. And there's, I was just making the two short points. One is there's no claim for rectification. It's not said that there's no claim that this needs to be the words in the contract wrongly recorded the agreement. That's the first point. And the second point is there could be no such claim, because when you come to the claimant's evidence on this, his evidence in terms is that there was no mistake in recording the agreement.
Yes.
So in my submission, that my learned friend doesn't grapple with the test or its application. The test is there an obligation to bring a claim in Beirut? The answer is that, and then there can be no doubt that's the test. And then the next question is, does this contract impose an obligation to bring a claim in Beirut? Answer, well, it says the parties shall do that. So it's just unarguable that this is a non-exclusive agreement. So then the next question becomes, if it's an exclusive jurisdiction agreement, as I say, should Your Honour nevertheless disregard it or allow the claimant to disregard it and bring a claim in these courts instead of in Beirut? Now, I preface what I say here, Your Honour will know, and you've heard submissions from me in other cases about whether or not there is a discretion at all on the legislation. And I say that there isn't, but I'm not going to go into detail on that, because I accept that on the current state of the authorities, you're bound by this decision in Karafi from some time ago, which says there is a discretion. So I preserve that if needs be for a later date. But so we're going to approach this on the basis that Karafi applies, and I'm just going to remind you, if I may, of what the Court of Appeal said in that case. And you will find it at page 776 of the bundle. It's in bundle F3, but 776 is the relevant passage.
It's taking a while to load up, I'm afraid.
That's quite right.
Due to the internet problem I'm having. Perhaps you could read me the relevant.
Yeah, of course. Let me help you with that. So it's paragraph 113, which says the proper approach to this issue in English law, subject to minor modifications, was laid down 42 years ago by Mr. Justice Brandon in the Eleftheria. The judgment was approved and adopted by the House of Lords in Donoghue and Armco, which you'll be aware of. Paragraph 114, the overriding principle is that the English courts will give effect to foreign jurisdiction clause unless strong cause can be shown why effect should not be given to it, and then refers to page 242 of Donoghue and Armco, which summarises some of the principles. Now, I think my learned friend rather stops there, because some of the principles that are summarised there are what we would call forum non-conveniens type factors. But nevertheless, the Court of Appeal goes on in this case to make the point, paragraph 115, it is right to add that in subsequent decisions, the strong cause hurdle for not enforcing a foreign jurisdiction clause has been set at a high level. The underlying approach can be summarized by saying that the parties should be kept to their bargain unless to do so would or might cause some serious injustice to one party or the other, or both, and goes on to give the particular example. Now, in Carafi, the particular ground that was applied, and Your Honour has applied it in other cases, was that there might be a splitting up of two cases which belong together. But it's right then that on this authority, and for your purposes today, the court retains a discretion to hear a claim in the face of an exclusive jurisdiction agreement, but the claimant must show strong reason for your doing so. And the burden is on the claimant. And what I just suggest is that the court should not lose sight of the fact that that is a difficult test to satisfy. And so in the authorities in England, this requirement for strong reasons has been said to require something overwhelming. That is the word that is used, some considerations that are overwhelming. And there's a case in particular where you can see that very briefly, which is a case called Antec, which you'll find in bundle G at page 795. Actually starts at 783. Sorry, 785. 785. No, it's not. I'm so sorry. It's 985. Now, this is a case which concerned a non-exclusive jurisdiction agreement, and the argument was whether or not the court should nevertheless in England refuse to hear the case, even though the parties had agreed to the non-exclusive jurisdiction of England. But in that context, the courts have confirmed that the strong reason test is the same, where you're trying to resist jurisdiction on forum non-conveniens grounds despite that sort of agreement. And the relevant part, page 985, as I say, paragraph 7.2, although in the exercise of its discretion, the court is entitled to have regard to all the circumstances of the case, the general rule is that the parties will be held to their contractual choice of English jurisdiction unless there are overwhelming, or at least very strong reasons for departing from this rule. And then little 3, such overwhelming, this is significant, such overwhelming or very strong reasons do not include factors of convenience that were foreseeable at the time that the contract was entered into, save in exceptional circumstances involving the interests of justice. And it is not appropriate to embark upon a standard spiliada balancing exercise. The defendant has to point to some factor which it could not have foreseen at the time the contract was concluded. So there are a few things to bear in mind when approaching this exercise. And once again, it's probably easiest just to show you those in the Joseph textbook, if I may. And the first point is that this is not a forum non-conveniens exercise. Forum non-conveniens factors, the convenience of the parties, generally are irrelevant. And we can see that in the Joseph textbook at page 1107. It's the beginning of tab 15, G. And I'll just show you a very short bit of these. It's paragraph 10.01, about 5 lines from the bottom, if you have that. It says, nevertheless, in the field of jurisdiction agreements, the forum non-conveniens discretion has become highly circumscribed by precedent and the Brussels I regulation recast. Special considerations apply, and the principles set out in the House of Lords in Spiliada are of limited relevance. As is discussed in this chapter, the traditional view is that the English courts will keep the parties to their bargain on jurisdiction unless strong reason is shown. And then you'll see at 10.05 on page 1109, you'll see there just 4 lines down from the bottom, from the top, sorry, 1005, page 1109, the requirement of showing strong cause or strong reason has been interpreted as requiring something which would be overwhelming. So, and then the second point which I wanted to make was that the court is generally not entitled to, or the party is generally not entitled to ask the court to weigh up the relative merits of fighting the action in the two different courts. And we see that if we go down to page 1112, in paragraph 10.12. And you'll see 10.12, His Honour Judge Chambers QC in JP Morgan Securities considered, rightly it suggested, that the court was not concerned with that minute evaluation of witnesses, documents, law and locality that characterise the standard forum non-convenience disputes. Specifically, the factors referred to by Mr. Justice Brandon in subparagraphs A and C in the passage cited from his judgment would not support an application for not giving effect to the jurisdiction agreement. In British Aerospace, Mr. Justice Waller, as he then was, further considered that generally, where parties had freely negotiated a jurisdiction clause as opposed to it being part of a standard form contract, it would not be open to a party in the course of a jurisdiction challenge or a stay application to rely upon forum non-convenience grounds if such matters were foreseeable at the time of making the contract. And then if I can ask you to look in the middle of the page here, do you see it's the sentence that starts outside the realm of jurisdiction clauses?
Yes.
Matters
Yes.
such as the recovery of costs or court delay are frequently taken into account. With choice of court agreements, however, it would be an exceptional case which would permit courts to take into account factors such as costs or delay in the chosen forum. Except in a very rare or exceptional case, a party cannot be heard to complain of these types of features in the courts that the parties by contract have chosen. So the third point there that we've just really seen is that what was foreseeable, not just actually foreseen, but what was foreseeable at the time of contracting is not relevant for the purposes of your assessment. And the way that the part, we refer to this in the skeleton, we don't need to go to it, it's a very short passage, but the way that courts have put that is that the parties should be taken to have contracted for those features of the system, the chosen system. What about when a party says, well, there's such serious problems with the legal system that we've chosen that its integrity is in question? And in relation to those sorts of complaints, the court adopts what I would characterize as deep skepticism. There must be, what needs to be shown in those sorts of cases is that there is a real risk that justice will not be obtained as a result. So a real risk in this case that justice would not be obtained. And the courts have said on various occasions that they should be extremely cautious before reaching that sort of conclusion. Just show you two short passages on that, if I may. The first is at page 1039, which is in a case called AK Investments. (1039), and it's paragraph 97 of that case. I think we may have lost the judge again. I can now see you, Your Honour, and you're no longer frozen.
Okay, can you hear me now?
Yes.
Yes, all right, thank you. I'm trying everything I can at this end, but the service is just hopeless. It keeps on dropping in and out, I'm afraid.
We'll battle on.
Yes.
So I was taking you just to that passage in AK Investments. I don't know whether you had that.
Yes, I did, thank you.
And that was the conclusion that extremely cautious was the phrase that was used by the Privy Council in that case. The other point is that when that sort of allegation is made, it is a serious one and it has to be advanced seriously, and that requires the usual procedural and evidential safeguards. And again, it's a very short passage in the case of Deripaska and Cherney, which you'll find at page 1010. And it's paragraph 60. And then the point is that allegations of a kind that impugn the integrity of the institutions of a friendly foreign state should neither be made nor entertained lightly, but must be distinctly alleged and supported by positive and cogent evidence. And goes on to deal with the sorts of allegations of corruption that were being made in that case. So you need a properly particularized allegation if you're going to make those sorts of complaints. It must be supported by positive and particularized and cogent evidence, and not by unparticularized allegations, unparticularized generalized material. Just in terms of this court, before we get to the actual complaints that are made, I just remind Your Honour that this court has emphasised the importance of jurisdiction agreements in its own favour. And so in the Barclays Bank case, Your Honour was on the Court of Appeal in that case, where the court refused to enforce a judgment which had been obtained in breach of a jurisdiction agreement in favour of this court. And I would suggest that this court needs to be scrupulous about treating jurisdiction agreements in favour of foreign jurisdictions equally seriously. And so it shouldn't just give in to parties who are in reality simply changing their mind about where they want to bring their case. And then the other point is that this is the particular jurisdiction we're dealing with is Lebanon, in fact, Beirut in Lebanon. Lebanon is a member of the Riyadh Convention. There are treaty obligations, amongst other matters, to ensure that these courts and other courts in the UAE assist the Lebanese courts with their cases, taking evidence and thus and the like, and with the enforcement of judgments. And we say that makes it an even more unlikely conclusion that these courts should say that the Lebanese courts are not to be trusted with this case or any other case.
Mr. Montague-Smith, I'm having real problems at this end. I'm going to try using my phone. So, Matha, are you still there?
Yes.
Can you send me can you send me an email with the link to this Teams meeting so that I can try and join by phone?
Certainly.
All right, let's try that, Mr. Montague-Smith. Sorry.
Not at all, not at all. Just to recap, because again, I'm not quite sure when you dropped off, but the 2 points I was making was firstly, in the Court of Appeal, Your Honour was part of the Court of Appeal in the Barclays Bank case, where the court refused to enforce a judgment of a friendly local court because there was a jurisdiction agreement in favour of the DIFC courts. And so I was suggesting that this court needs to take foreign jurisdiction agreements just as seriously and treat them equally, so as not to expose itself to complaints of hypocrisy. And then the other point I was going to make was that Lebanon is in fact a Riyadh Convention state. And so there are treaty obligations on the UAE to ensure that its courts do certain things, including giving assistance to Lebanese cases through evidence and so forth, and enforcing Lebanese judgments. So in light of those obligations, I would suggest it's even more unlikely that the DIFC court is going to say, well, we just don't trust, they're not to be trusted with cases. In the skeleton argument, my learned friend's skeleton argument, she sets out the various factors that she relies on to say that they amount to strong reasons why the court should not enforce an exclusive jurisdiction agreement. And they're set out in paragraph 29, and the first four of them are all about forum non-convenience. So they're factors like where the agreement was negotiated. It's not clear why that would be relevant in any event, but things like Lebanese law can be called by expert evidence. There's some submissions about the merits. Now, I don't accept those assertions at all. So, for example, it's not correct to say that the defendants have conceded the claim. That's simply not accurate. The whole point of this application is that the defendants should not need to defend their claims in the DIFC. And they can't do so consistently with this application. If they started to engage on the merits, no doubt my learned friend would say that they'd submitted or waived jurisdiction objections. The merits are never, even on a forum non-convenience analysis, relevant. Similarly, I don't accept the assertions about witnesses and documents. My learned friend doesn't even say what relevance particular documents or witnesses would have to the dispute. The only clear factor is that Lebanese law applies, which of course favours the Lebanese courts. But all of that sort of thing is entirely irrelevant. Those are effectively forum non-convenience factors which were foreseeable at the time of the agreement, and the claimant must be taken to have agreed to those features of the Lebanese system. The one that doesn't fall within that category is what she says at paragraph 29E, where she says that or might not fall, which is at 29E, she says the claimant would be prejudiced by having to sue in the Beirut courts.
Yeah.
For reasons that are set out in the report of Mr. Malouf and below. So the focus of the complaints is what's set out in Mr. Malouf's report and in various places said to be below. Now, what is actually alleged, and you'll recall, as I pointed out, the complaints of this sort, complaints about the integrity of the system, must be distinctly alleged and proved with cogent evidence. The only complaint that is in fact alleged, at least in the paragraph, in the particulars of claim, is the question of delay. And there, what is said, it's paragraph 49 of the particulars of claim, we don't need to go to it, is that, that there is an allegation that there would be what's referred to as very substantial delay if the claim proceeded in the Lebanese courts. And there's no assertion of how long it would act. I hit mute by accident. There's no assertion, there's no statement anywhere in my learned friend's pleadings, evidence, arguments at all of any estimate of how long the proceedings would be likely to take. So normally, when you've got an allegation of this sort, you'd have an expert who would say, oh, in my estimate, this will take X years, or whatever it may be, and then we've got a yardstick by which we can assess that. Because we'll come on to see it, but for example, in the Celeran case, no less than Mr. Justice Collins, Lord Collins as he became, said 4 or 5 years was not a factor which would be taken into account in a forum even in a forum non-convenience argument. So delay is what is pleaded. Now, in addition to that assertion, the particulars of claim recites certain passages from the report of Mr. Malouf, and we see that. Well, we may as well look at it. It's at page 681.
Well, what do you say about Mr. Malouf's report, Mr. Montague-Smith? You, in the skeleton, you take a point about no leave having been sought.
Yes.
You maintain that point, or?
Yes. And the reason why is for various reasons. It's not just a technical complaint. My learned friend needs permission to rely on that, and permission is important. So the control of permission for expert evidence was introduced for a reason, and the reason was to ensure that precisely this sort of thing doesn't happen. What you have here is you have someone who works for the claimant's own lawyers giving a report. So he's not independent. He's not an independent witness in any way. So I can show you this very briefly. you've got Wassel and Wassel, which is, I assume, a Lebanese law firm. The managing partner is giving evidence on behalf of the claimant in these proceedings. That's not Mr. Malouf, it's Mr. Abu Wassel. You'll see that at tab 6, page 78.
Yes.
And you'll see
Yes.
what so he says, my name is Mr. Abu Wassel. He's the managing partner of Wassel and Wassel. Paragraph 2, my firm is engaged and instructed by the claimant. Paragraph 3, my firm is the instructing firm to Sol International, right? And then if you go to the report, which you'll find at B6695, starts at 692. But if you go to his report at 695, paragraph 8, I declare that I work as of counsel for Wassel and Wassel. So with respect, he's not an independent expert. And he doesn't even, as the rules require, say that he understands that his primary duty is to the court rather than to his client. So there's a requirement in the rules for a statement to that effect. That is an absolutely essential duty. It's not formalism. It's an absolutely essential duty that the expert needs to understand that their primary duty is to the court. He's not here to argue a case. And that's all made clear in the rules. But he doesn't even say that he understands that duty. And he works for the firm. He's been instructed by his managing partner to produce a report in this case. So I say it's not a technical point. I'm not simply saying, that well, a friend hasn't asked for it, so you shouldn't give it. What I'm saying is, if she asks for it, permission to use this report, you shouldn't give it, because this is not the sort of report that qualifies. And if we go on to see what he actually says, we say he's demonstrably wrong about a number of things. And it's one of those situations where he doesn't appear to know what he doesn't know. He doesn't appear to know where the exceptions lie. So I'll come on to this in a moment, but in particular, when you look at the issues, so there's 3 issues effectively that are raised. One is delay, one is the effect of the falling exchange rate, and one is a shadow of an accusation of corruption. In relation to the exchange rate issue, just to give you an example, he seems completely unaware of the actual law. So he ignores or is unaware of this critical distinction between the domestic contracts and international contracts. So the argument goes, well, the Lebanese courts allow parties to pay out contracts in US dollars, debts in US dollars, in the local currency and an artificial rate. And the result of that is that he's not going to get his money, or he's going to get less than he's entitled to. But what he completely fails to understand is that none of that applies. There is a debate about that, and he's probably wrong about that, but none of it applies in relation to international contracts. So he's looking at the wrong cases. He's looking at the wrong decisions. I'll come on to that. But the result of that is that the conclusions that he confidently pronounces are all, I'm afraid, suspect. In case you do give permission to rely on Mr. Malouf's report, the defendants have applied for permission to rely on the evidence of Professor Haj Shaheen. I don't know if you've had a chance to look through his report.
Yes, I have. Thank you, Mr. Montague-Smith.
I'm grateful.
And I'll ask Ms. Malik to address me on the question of whether leave should be granted in due course.
I'm grateful. Just to be clear, I'm not taking a technical point that the words haven't been said, please give me permission. The point is about the quality of the report.
Yes.
But when you read Mr. Haj Shaheen's report, you'll see that firstly he expresses himself in measured terms. He actually provides support for his conclusions. They're not simply assertions. And plainly, he has the relevant expertise. He's a professor of law in Beirut. He's a professor of law in Paris too. And on the issue of the exchange rates, which I've just been mentioning, he's recently had published a study on that precise issue, which you'll see, and I'll take you to very briefly to some of that. So he's genuinely an expert in the issues that he's addressing. He's not, with great respect to Mr. Malouf, just giving what appears to be uninformed opinion, backed up by whatever he comes across in the authorities. I will, though, deal with the complaints themselves that are made. As I say, the first of those appears to be that there would be delay. I've shown you the authority which says that delay is one of the factors which would require a very exceptional case before it could be taken into account. And to get a sense of the yardstick here, Your Honour should note that in the Chellerham case, which I've referred to in the skeleton, Mr. Justice Collins, as he was, said that a expected delay of 4 to 5 years was not a factor to be taken into account, even in a forum non-convenience case. So that's the yardstick that you can consider. 4 or 5 years is not enough. But also, Your Honour has to consider the foreseeability issue, because even Mr. Malouf says that delay has been a problem in the Lebanese courts for a long time. So in other words, it was a problem, or it was a consideration in 2019 when the contract was agreed. So you would need to be satisfied that the delays have got worse since the contract was entered into, such as they are now, wholly exceptional, and amount in effect to a denial of justice. So what is the claimant's evidence on this from Mr. Malouf? How long does Mr. Malouf say this case would take? How much longer does he say it would now take compared to how long it would have taken in 2019? And the answer is, we don't know. He just doesn't say that. All he does is he makes generalized complaints that there will be what he refers to as substantial delays. If you're still in bundle B, tab 6, I can show you what he says. If we go to page 699.
Yes.
First of all, he sets out from paragraphs 27 onwards a series of assertions about the state of the judiciary in Lebanon. Now, none of this is specific about how these particular individual factors that he asserts will prevent the court or hinder the court in dealing with this particular case. So there is, for example, complaints about lack of stationery, about resignations, about staff shortages, but there's nothing to say, at least in this section, how that would affect the case, even if you accept those assertions. That's all in the next section. So the next section starts on page 701. You've had a chance to read it, you'll be familiar with this.
Yes. And
question 4 asks the leading question: did all these circumstances lead to the lengthening of trials in Lebanon? I mean, it's difficult to see how you could be much more leading than that. Was it a real problem? Paragraph 33 then says this: justice in Lebanon has historically suffered from sluggish trials, some cases taking several decades to decide. On average, trials last for 3 years in Beirut and 4 years and 3 months in the Mount Lebanon region. So on average, that's how long they've taken, and apparently that's how long they've always taken. Paragraph 34 talks about lockdown caused by a backlog. 35 talks about a bar association strike, and here he does say how that is said to have impacted on the length of trials. He said it exacerbated backlogs and delays, but that is it. We don't know by how much. And then paragraph 36, he refers to a strike by court staff. And paragraph 37, he says, well, the result is that there's a depressed atmosphere. And in terms of delay, he just says it has extended the duration of trials without end. Now, that's obvious hyperbole. Clearly, it's not extended without end. He doesn't actually say how long it takes to get cases through the system. And the only sources he cites are 3 internet links. 2 of them, if you click on them, don't work. The third takes you to a site in Arabic. And if you risk that click, you can get Google to translate it for you. And all it is a report from September 2021 that a strike was announced. So it doesn't tell you what the impact is, it couldn't, because it's at the start, not later on. So this, we say, is a long way from being the sort of cogent material to show that there are extraordinary delays justifying disapplication of a jurisdiction agreement. Now, Mr. Haj Shaheen doesn't accept these views, and he has provided detailed evidence, including statistics of actually how the courts are operating. You can find that in tab A if we go to page 253. If your honour's had a chance to read this, you'll be familiar with all of this, and you'll see that he accepts that there have been challenges, but he points out a few things that Mr. Malouf neglected to mention, such as while there was a court staff strike, there were still staff, and they were rotated, and hearings went on, and the strike was lifted. And not all of the advocates were on strike, so cases did go through, and the strike was temporary. As to statistics, the only ones that we have available are those for the Court of Cassation, and those show that between November 2019 and February 2022, they show that the court was clearing its backlog. If it's clearing its backlog, that means there can't be any exacerbation of delays, quite the opposite. Those statistics come from reports from the clerks of the Court of Cassation. If you want to look at those reports, they're in translation at page 284, but they don't say that. We have prior statistics for other courts, but not for this particular period. And so the only hard data that you have is that the position is improving. The courts are clearing their backlog. And so what Mr. Haj Shaheen says at page 256 is that he still thinks that 3 years is about right. That's paragraph 39. So he does not see that there's any evidence of actual delays of the order that would justify bringing this claim in breach of the clause. And that 3-year estimate is the only estimate you've got. It's the only estimate you have about how long this trial would take in Lebanon, and it's not changed. My learned friend makes specific complaint in this context to the expiry of the body called the Judicial Council, the expiry of their term in May 2021, which Mr. Malouf said led to paralysis. It referred to in a skeleton argument. Mr. Haj Shaheen points out this had no material impact. You'll see that at page 254. Because the Supreme Council, the Judicial Council, they're not judges. They don't decide cases. And anyway, he points out that new members were appointed in October. So there was a period between May and October 2021 where there was a gap. But even during that time, their duties were continued. So that is a totally overblown complaint, which had no impact whatsoever, or could have no impact whatsoever on this case. So as to delay, there's just nothing there that could justify going around this jurisdiction agreement. The next issue is exchange rates. Just to explain this, there was a passage from Mr. Malouf's report, which was included in the particulars of claim. So in a sense, this was raised. And the complaint, as it's put in the skeleton, is that the courts, Mr. Malouf says, allow parties to pay US dollar debts in Lebanese pounds at an artificial exchange rate. That's the complaint that's made. There's actually another complaint in his evidence, and it's not clear whether that's relied on or not. But I'll just show it to you very briefly, and then I'll come back to the original one. If we go, please, to page 702.
702?
Yes, please. We were just at 701.
Yep.
And if you've seen the question, do Lebanese laws include provisions that allow national courts to address the economic and financial collapse that the country is witnessing? In this section, Mr. Malouf makes the complaint that the Lebanese legislator has not intervened to rebalance contracts which have been affected by the devaluation of the Lebanese pound. In paragraph 40, he refers to the theory of exceptional circumstances, which he says allows judges to intervene to restore balance. And he says, well, that they changed the law in France and the Lebanese should have changed the law too. And he talks about Article 1195 of the French Civil Code. And this is another example of him just not understanding the exceptions, because what he doesn't realize is that these provisions that he's talking about and the theory of exceptional circumstances, they don't allow rebalancing of monetary obligations. They're not to do with debts. They're to do with non-monetary obligations. And Mr. Haj Shaheen sets out why that is the case in his report at page 259, paragraph 53(3). That's so debts are debts. You can't have judges coming in and saying, well, the money that you promised is now worth less, and therefore I'm going to say that you have to pay less. Whether you're in France, Lebanon, or anywhere else, it doesn't change things. And Mr. Haj Shaheen also provides the relevant provisions of the Civil Code if you're interested in going that deep into it. But none of this, we say, is in any way relevant. Why? Because this is about the law of Lebanon. This is about Lebanese law. So it has nothing to do with getting justice in Lebanese courts. If the DIFC courts heard this case, they'd have to apply Lebanese law too. But what it does do is it demonstrates that Mr. Malouf is, I'm afraid, straying into areas which are clearly beyond his expertise. And it's a problem of it's a problem of the barrack room lawyer. The main problem is not knowing what you don't know. If you don't know where the exceptions lie, you see a principle in a case and you apply it to everything. So he sees a principle of exceptional circumstances and thinks it applies to all obligations. He doesn't know where the exceptions are. And the same problem arises in the next issue he raises. So the second issue, and this is the one that's recited in my learned friend's skeleton argument, he asserts that the Lebanese courts, he says, allow US dollar debts to be paid in Lebanese pounds at an artificially low rate. It's slightly different from the first point. So what the complaint is that Lebanese pound has plunged. There is now an artificially official rate, and the result of that is that if you owe money in US dollars, you can actually pay that debt at a very low exchange rate, which isn't realistic, and therefore get away without paying a proper amount for your debt. There are any number of problems with this, and Mr. Haj Shaheen deals with them comprehensively. But the central one is this, that Mr. Malouf simply misses the key distinction between domestic and international contracts. And I need to show you this, if I may. It's at page 270. Paragraph 97.
Yes.
With regards to international contracts, it is settled case law that payment must be made in accordance with the provisions of the contract, and the creditor cannot be forced to accept a payment in local currency, and then refers to the authorities in it, both from cassation level and enforcement level. It is clear that there is no application of these sorts of problems to international contracts. There is a debate in the authorities, an unsettled debate, as to whether or not this principle applies in relation to domestic contracts. In relation to international contracts, it's settled to cassation level. Mr. Malouf doesn't see the difference. And then paragraphs 98 to 100, Mr. Haj Shaheen sets out the test for what is international and why this contract satisfies that test. So this is just a red herring, and one which we say does further damage to Mr. Malouf's credibility. And Mr. Haj Shaheen, in fact, as I mentioned at the outset, has produced an extensive study on this very issue, which was published in March. You can see it. If I can just show you very briefly where it is. It's page 500. It starts. I'm not going to take you through all of it, don't worry. But he actually deals with the question comprehensively. So if you have any doubts about this particular problem, all of the answers are in this document. And you will see he makes the point that there's a distinction between international contracts and what are referred to as internal contracts. And he says resolving this issue in international contracts does not pose any serious problem. because the Lebanese jurisprudence is stable, considering that the debtor is obligated to pay the debt arising from an international contract in the foreign currency stipulated in the contract. And then what he does in the rest of this document is he goes on to explain that while in relation to internal contracts, that's domestic contracts, there is doubt in the authorities, the right answer, he says, as a matter of Lebanese law, is that the debt has to be discharged in the contractual currency. Now, the problem, just so you understand what the underlying issue is in Lebanese law, is that, and Mr. Hajjeen explains it, is that part of the problem anyway is that there was an argument that in an internal domestic contract, an agreement to pay in a foreign currency is void. That's the centre of the argument. But again, that's a matter of substantive Lebanese law. So if that is the law, then the DIFC would have to apply it. But even if that wasn't right, so say that's not right, say it's not a matter of substantive law, but it's a procedural issue that arises. When does it arise? It arises at the point of enforcement. It's either a defence to the claim, in which case it's substantive law, or it arises at the point of enforcement, neither of which affects where the substantive rights need to be determined. It's not an issue which could, on any logical basis, affect the question of which is the right court to determine the substantive rights in the claim. Say you get a judgment, you're either going to enforce it in Lebanon or you're going to enforce it outside Lebanon. If you try and enforce it in Lebanon, you're going to come up against this problem. If you're going to enforce it outside Lebanon, either it's a feature of Lebanese law, in which case you're always going to have to face that problem anywhere, wherever it's tried, or it's not, in which case you won't have the problem. Either way, it doesn't affect where the substantive rights have to be determined. So none of that makes any sense. And then the final complaint that we detect is about the integrity of the Lebanese courts. And this is now made very faintly indeed. And the only point made in the skeleton argument is at paragraph 40. And it's at the end, it's on page 14 of my learned friend's skeleton. And she literally says it in a sentence. She says, and there are concerns about politicians interfering with legal proceedings in Lebanon. That's the assertion that is made. And she refers actually to a passage in Mr. Hajjeen's report. In fact, that paragraph is at page 257 of the bundle. And he says there is a public perception of interference, largely in criminal cases, but then goes on to explain why that could have no relevance in this case. And so I think the critical point here is that there isn't any case, let alone evidence, that this case could be affected by those sorts of concerns. You need to explain why it would affect this case. I want to ask the question rhetorically, why would a politician, even if they could, interfere in this case? There's no explanation or evidence to affect that. So we say none of these considerations that are raised are relevant. Certainly none of them are made out to the sort of strength that you would require to say, yes, okay, the parties have agreed that they will only bring their proceedings in Lebanon, but I'm going to let them do it here anyway. This is an absolute paradox. One asks the question, if this jurisdiction agreement is not going to be enforced, which ones will? Your Honour, that was what I was going to say about the jurisdiction agreement, and then I was just going to deal very briefly with the two other issues, underlying jurisdiction and service, and then I'll hand over to my learned friend. I'm not going to dwell on these. In terms of underlying jurisdiction, the way it's put is that the claimant relies on Article 5A1B. That is on the basis that the contract was partly concluded in the DIFC. Now, again, on this, there's an issue that can be parked at first instance because we say there's a problem with the translation of Article 5A1B. And the problem, just so you understand what I'm saying, is that the words partly or wholly in that provision don't qualify the word concluded. So partly concluded is not sufficient. Actually, if you look at the Arabic text, partly or wholly applies to performance, not to concluded. But I park that issue because I accept that there's authority that goes the other way. So your Honour doesn't have to worry about that. That's Karafi again. And
Yes.
in Karafi, what was concluded was that what was decided was that partly concluded could be satisfied if the contract was negotiated in the DIFC, but it doesn't go as far as what the claimant relies on, which is that in effect the contract was partly negotiated in the DIFC. And I set out my submissions in relation to this in my skeleton, and I'm not going to go through it in too much detail, but just to remind you of the facts of that case. Firstly, the case that was put in Karafi was that the contract had been concluded, actually agreed, in the DIFC. And what the Court of Appeal found was that there were two entities, one Swiss and one DIFC, and all of the documentation, all of the negotiation had passed through the DIFC entity. So the entire contractual negotiation and the conclusion had gone through the branch in one way or another. And so what the Court of Appeal said is they didn't reach a landing on whether or not it had actually been concluded in the DIFC, but they said in those circumstances, given the scale of the negotiation, it had been at least partly concluded in the DIFC. Now, in the present case, we've got a much more limited connection with the DIFC. We don't have either party being situated in the DIFC. What we've got in effect is lawyers acting for one of the parties, one office outside the DIFC and one office in the DIFC. Now, I think my learned friend now accepts that the Mays Tower office is not in the DIFC, but she said her client didn't know that. Well, that's neither here nor there. The point is that, and Mr. Gannon gives evidence about this, he led the negotiations. So when Tamimi and Co were appointed on behalf of the defendants, he was the individual with conduct of the claim and of the negotiations, and he was based outside the DIFC, and that is where most of the negotiation went through. Now, it is right that in the latter part of those negotiations, Mr. Essam Al-Tamimi, the principal of Al-Tamimi and Co, he participated in the negotiations. He was brought into them actually by the claimant, and he engaged in some telephone calls and he sent some emails. Now, but he fairly says, and Mr. Gannon records this, Mr. Al-Tamimi accepts that he cannot recall where he was at the time that he made those telephone calls. And so what we say is that the only concrete evidence of any negotiation happening in the DIFC is a single meeting in April 2019. So we accept that a meeting took place and negotiations occurred at that meeting. And so if some negotiation is sufficient, then we're in. But if you need more than that, we're not. And what we say is that if you ask the question substantially, where was this negotiated? The answer is not in the DIFC. It certainly wasn't concluded in the DIFC. It was concluded in writing outside the DIFC. And I don't think that's disputed, and there's evidence of that, and we've referred to it. But unless some part negotiation through lawyers is going to be sufficient to attract the jurisdiction of this court, then there is no underlying jurisdiction. So the question is part negotiation enough? Al-Karafi does not drive you to that conclusion. And I would suggest that going that far is too far, because one of the points I make is simply that if you go that far, it's going to be very easy to confer jurisdiction unilaterally. I'm having a negotiation with my opponents. I can take my telephone or my laptop and go and sit in a cafe in the DIFC. Nobody knows about it. I send an email from the cafe. I have a conversation on the telephone from the cafe. That's part negotiation. And all of a sudden, the DIFC court is saying, well, we've got exclusive jurisdiction. We say that is throwing the gates open too wide as a matter of policy. You're not driven to that. Yes.
Mr. Montague-Smith, if the case were to turn on this, and of course you run a number of arguments otherwise, but if the case were to turn on this, there is, I think, some uncertainty on the evidence as to precisely what took place within the DIFC. And in particular, we don't have direct evidence from Mr. Al-Tamimi. and it's secondary evidence through Mr. Ganem, and he refers to Mr. Al-Tamimi not recalling where he was when the various discussions took place. So if the case were to turn on this, would this be one of those cases in which the threshold would be, in other words, is there an arguable case for jurisdiction on the basis that the actual case for jurisdiction would have to be tried as part of the substantive proceedings, on the basis that witnesses would have to be called, determinations would have to be made of fact, which would influence the outcome? What do you say to that proposition?
That's one way you could deal with this. The precise. I hear what you say about the potential for a factual debate. What I say though is actually, if you look at that evidence, that's all about the latter end of the negotiation. That's the last bit. So Mr. Assam Al-Tamimi was brought in to clear the logjam. There was a particular point that needed to be cleared away, but the predominance of the negotiation actually was through Mr. Ganem outside the DIFC. So it depends on where you draw the line, where the threshold is. All right, and it seems to me, I'd suggest that it would be somewhat arbitrary if the line was drawn at, well, the question of whether or not, if it all turned on whether or not Mr. Assam Al-Tamimi was sitting in his home office or sitting in his DIFC office when he sent an email. That's really fundamentally the point. No one can really know from the outside whether that is the case, and so can it really be right that DIFC jurisdiction should turn on that? The better answer is that as a matter of law, if it's right the negotiation is enough, which we dispute, but you're bound by it, then it must be a binary question. Where in substance was this negotiated? In substance, it was negotiated outside the DIFC. It was concluded, certainly, outside the DIFC. Is it enough that there were a few, even if you were to say, I don't know where Mr. Al-Tamimi was when he had those telephone calls and where he sent those emails, but on balance, there's credible material for now to go forward. Is that going to be enough to shift the center of focus of those negotiations from outside to inside? That's the way I'd ask you to approach it, and I'm not going to ask you to sort of put it all off to trial, if I could put it like that. I don't think that would be the right approach. So that's there's a question of law. There's potentially a question of fact, as you've discussed, but on the law, I suggest that you should resolve it in a way which makes the test workable. Is it in substance a contract that was negotiated inside or outside the DIFC? That's all I was going to say on the underlying points, unless you've got any other questions.
No.
Questions of service then, finally. And we say it's just clear beyond doubt that the claim form was not properly served. We need to look at both defendants individually. The first defendant is in Lebanon. So they need, in each case, they need to be served in accordance with the local rules. And in Lebanon, service was by courier. That is not a valid form of service. And you can see the Lebanese code is at G13, page 1090. Article 398, service must be made by a process server, by police or gendarmerie officers or a clerk. Couriers are not on the list. And so that's the end of it. What's the answer to this that's given? In the skeleton argument, the answer to this is, if you've got that page, I'll show you the particular provision that's relied upon. The answer to this is at paragraph 46. And my learned friend refers, of the skeleton argument, my learned friend refers to Article 413 of the same code.
Yes.
And it doesn't make any sense, because if you go down to 413 of the Civil Code, which is on page 1095 of the bundle,
Yes.
you'll see that deals with service on people who are outside Lebanon. So there are clearly two rules, one for service inside Lebanon, one for service outside Lebanon. 413 says, where the service of process is addressed to a person residing in a foreign country, it shall then be served by a certified letter against receipt or through the Lebanese embassy. So here we're dealing with service on the first defendant. First defendant's a Lebanese company. The whole point is that this is about service in Lebanon. That can't work. So it's accepted that service was by courier. That is not a valid form of service. That's the end of that point, we say. Now, in relation to the second defendant's in Singapore, the rules for service are more liberal. Service by courier in principle is acceptable, but the problem here is that the claimant served the wrong address and the wrong entity. So just to remind you of the actual name of the second defendant, it is Khatib and Alami Partners Pty Limited. So partners, Khatib and Alami Partners. It's part of the Khatib and Alami group. And you'll see what they say about service here. If we go to page 79 of the bundle, it's in bundle A, behind tab 6. You will see paragraph 7. So this is, if you recall, Mr. Abu Wassel's witness statement. He says, paragraph 7, he reviewed the settlement agreement and didn't find any contractual notification address. So he researched Khatib and Alami Singapore and found their address listed at 1302 Peninsula Plaza. Do you see that? On 111 Northbridge Road. And then he says, this was the only website address for Khatib and Alami Singapore provided for the website. And so the initial research leads them to a web address. Just to pause there, if you go down to page 87, this is now MAWSO2. This is the document and the website that he's referring to. You can see that from page 86. But if you look at the document, that is contact details for a different entity. That is Khatib and Alami International, not Khatib and Alami Partners. So that gives the address 1302. So to pick up the story after what happens there, go back to page 79, please. Excuse me. Paragraph 10. Mr. Abu Wassel says, right, what do I do next? To confirm the address, I cross-checked the address with additional publicly available data, and found the company's information on a website named OpenGov SG. So that's the equivalent of the company's house company check. OpenGov SG had listed the same address for the Singapore office that I had previously found on the official website at 111 Northbridge Road, paragraph 12. However, there was one difference. The address listed was 1302, that's the original one, whilst the address on OpenGov SG website was 2403, which is obviously a different office in the same building. It's a completely different address. So what he does, he says, to confirm the address, he checked the LinkedIn and he decides that 1302 is the correct address. And if we go down to page 89, we see the OpenGov website, and that is for the correct entity. You see that? Do you see at the bottom of the page Khatib and Alami Partners, and the address is 2403. So that's the address. And then page 95, you see the LinkedIn website, which is for Khatib and Alami, and it gives the 1302 address. So that is clearly for the other entity. They have similar names, but they're separate. They're completely separate entities. So what's happened is that they've served at the wrong address. They've served the wrong entity at the wrong address. So the result of that, and we've pointed this out, and the result of all of this is that neither method of service has been done properly, and service should therefore be set aside.
Both defendants have filed an acknowledgement of service, haven't they?
Yes, but the way that you dispute service in the DIFC court, just like in England, is by applying to dispute the jurisdiction. You have to serve. That's how you have to do it. I mean, I can give you authority on that if you like, but that,
no point is taken against you on it. So
yeah, no, but that's how you do it. So you have to file. So this actually happened in another case where I think the registry took the point. They said, oh well, you say service was defective, but you filed an acknowledgement. So we applied to set it aside, and the judge said it was so obvious that the decision was wrong that we we shouldn't have actually made the application for a de novo. We should have just agreed it with the other side. So that's the way you deal with it. But so there is defective service in this case. But fundamentally, though, and the point, we certainly don't want you to I mean, we want an answer on all of these issues, but we don't want your Honour to avoid the main central issue, because that's the one that would apply if another claim was issued and another attempt was made. But fundamentally, the point is that the claimant should be held to his bargain. That's what these courts are for, to enforce contracts, and he should be obliged to bring his claim in Lebanon. So those are my submissions on those three issues. Unless you need anything further from me.
No, I have nothing further. Thank you, Ms. Malik. We've been going for a while, indeed, both counts. We've been going for a bit over an hour and a half now. This might be a convenient time for a break, during which I'll see if I can make some contact with my internet service provider and improve my connection. But would 10 minutes be convenient, Council?
Fine for us.
We'll leave the lines open, and we'll resume at let's resume at 10 minutes to the hour, shall we? That's a little over 10 minutes. So let's resume at 10 minutes to the hour. Thank you. So no luck with the internet, I'm afraid. I'm still on the telephone. So can you hear me and see me okay? I can't hear you, Ms. Malik. Are you still on mute?
Apologies. Yes, I was. No, I'm no longer.
All right, Ms. Malik, over to you.
Thank you. I'm grateful. Your Honour, hopefully I'm going to keep our position more simple. You've been taking a lot of the case law, but Mr. Montague-Smith's starting position is that there's an exclusive clause in favour of the Beirut court, and that needs to be upheld per se. And really, there is no discretion to depart from that, and the parties should be held to their bargain, if you like. Our position, as you'll see from our skeleton argument, is you cannot, and Your Honour, you did refer to these points, you cannot resile from the fact of the protracted 1 year of negotiations, which then resulted in this global settlement agreement, and what happened and was said during those negotiations, which I'll take you to, and the various drafts of the settlement agreement, including emails where jurisdiction was referred to as, if you like, in inverted commas, a hot issue. And that's important because on any contractual interpretation, which is what this matter rests on, the intention of the parties and what was in the reasonable, if you like, mindset of the parties, or what a reasonable individual would think was in the mindset, is of relevance. And ultimately, we say, in a nutshell, and I'll take you to the provisions, that the fact that the Beirut courts were referred to without the word exclusive being used, and I take the point that my learned friend says that exclusive doesn't always have to be used in order for it to be an exclusive contract. We've seen the commentary on that. Your Honour, I'm hoping you have seen Dicey, the commentary we forwarded this morning, and I apologise.
I haven't. That didn't find its way to me. It's not in the hearing bundle.
No, unfortunately, you may know that yesterday the hearing bundle was exchanged late. It's owing to the Eid holidays, owing to various kind of technical issues that occurred over the last few days. We didn't have a full kind of version of the hearing bundle. Skeletons were exchanged very late, which means preparation was again done very late. So this morning we sent an email, I think just around 9 o'clock to the registry and to the other side, just appending a chapter from Dicey to deal with the point that's made in my learned friend Skeleton argument. I don't know if we are able to get that to you, or Meta, you have that, and that could be forwarded on.
I'll ask Meta, could you have a look for that and send it to me if you could, please? But in the meantime, Ms. Malik, if you could just read me the relevant portion on which you rely.
You'll see from Percy, if I take you to my learned friend's Skeleton argument, you'll see what they say, or their position is that, sorry, just give me a second. Just misplaced it. Right here. It's the Skeleton argument at paragraph, my friend has taken you to it, paragraph 25 of their Skeleton argument, which is at page, it's in a bundle G, right? Yeah. Reference is made to and looking at transitive, i.e. positive obligations. In other words, where one says, we will submit disputes to the courts of Beirut, as opposed to an intransitive obligation, we consent to the jurisdiction without saying what they consent to, i.e. we're consenting to a dispute being submitted. That's the point of that paragraph. That the point that's being made is where there is a transitive obligation which specifically sets out what they intend to do, the verb is used, we will submit disputes, then that sometimes, by use of the word shall, makes it exclusive. But that's not the settled, I think we've lost the judge again.
No, you haven't. I've just lost the vision for some reason. I'm not sure, but I can still hear you, Ms. Malik, so please continue.
Of course, that's not the settled academic commentary on point. And the dicey chapter that I forwarded, and when you are able to access it, 12.105 makes it clear at the bottom. By contrast, an occasionally used rule of construction that a clause is exclusive if transitive in form, i.e. it says all disputes will be submitted to Beirut, i.e. the parties submit disputes, but non-exclusive if intransitive, i.e. the parties submit themselves, would appear to have practically nothing to recommend it. So this rule of construction is not an accepted academic rule of construction. There is academic, if you like, there's differing views between Dicey and Jackson on point. And why is that important? Because the contractual interpretation and where we ended up, we say, is hugely important. I'm going to take you to the history of these proceedings from the outset in terms of what the parties and certainly what our client understood in terms of the jurisdiction clause. And it is important. My friend rubbishes it by saying, well, it's neither here or there. And the claimant has accepted that what was written was correct. Well, no, we'll take you to his evidence, which says he conceded to that jurisdiction to get a deal done ultimately. And we'll see the emails between the parties that put pressure on, and indeed from Al-Tamimi, which talk about getting wrapped up in jurisdictional issues. But in any event, Your Honour, if I could firstly ask you to go back to the 7th of July. Well, if we start in March 2018, and it's within our skeleton argument as well, my client has a first meeting on this point with Mr. Essam Al-Tamimi in Tamimi offices in the DIFC. And very conveniently, it's dressed up as a clearance and discharge letter that's being looked at by Mr. Essam Al-Tamimi. A copy of that is before the court, and it's at page, if you just give me a second, I'll take you to that. Sorry, just give me a second. March 18, page 34 of A5 of the bundle. There's a draft settlement agreement that's shared in March 2018. At a point, my client has approached Al-Tamimi to talk about his departure from the defendants. Al-Tamimi give their views, give a draft settlement agreement in the DIFC, which talks about the shares. If you could please go to page 34, A5. Right. Where's the exhibit? The it's not this one. So I'm just pulling up the actual exhibit. It's not this one. Oh, is it this? Yes. It's page 44, Your Honour. This was the termination of partnership and employment relation of final settlement agreement and mutual irrevocable releases that was sent to my client by Mr. Al-Tamimi's DIFC offices when he met with him in the DIFC in respect of the now global settlement agreement that's been reached. And within the respondents or the defendant's position, they're saying, oh, this is not related. Their first position was this March 18 meeting was nothing to do with anything. It was simply my client having met Mr. Tamimi at a social event and wanting to know what legal mandates he could provide. When they were provided with emails to suggest, in fact, what Mr. Al-Tamimi did was, from the goodwill of his nature, provide legal advice in relation to the termination of my client's position with the defendant, and you see that there. In that particular agreement, there is no jurisdiction clause, but it's an agreement that started with Tamimi's in their offices in March 2018. 2 months later, Tamimi's are instructed by the other side on the same matter. They are then dealing with the defendant's position to terminate or to release my client from his obligations under the employment contract. So putting aside conflict issues, putting aside all of those matters which we've raised in our skeleton argument, when the position or when the agreement started, it started within the DIFC. You can call it a clearance and discharge, you can call it global settlement. It's one and the same thing. This agreement kick-started the process. What happens next? On the 7th of July 2018, if you go to page, I think it's 49. We just go to that. Yeah. We have an agreement where the agreement shall be governed by and construed in accordance with the laws of the Dubai International Financial Centre. So the first global settlement agreement, if you like, once Tamimi's have now been instructed by the opposition. And Your Honour, just so you're aware, on the 10th of June 2018, my client wrote to Tamimi's once he realised that Mr. Fadi Ghanem was involved to say, are you really involved in this matter, given I've had advice from you in this matter from Mr. Tamimi? In any event, in that agreement, the 7th of July 2018, the DIFC is referred to as an exclusive jurisdiction. You'll see that at page 40, page 49, paragraph 14. This agreement shall be governed by and construed in accordance with the laws of the DIFC. The parties agree to submit to exclusive jurisdiction with regard to any dispute. Thereafter, on the 6th of November 2018, and this is A8, Your Honour, at 167. There's another version of this agreement where it talks about the laws of United Arab Emirates applying at paragraph 18. All disputes that may arise between the parties shall be referred to and settled by the Dubai courts. And then on the 27th of November 2018, A8181, the version that you have before you, aside from the word execution was added, this agreement shall be governed by and construed in accordance with laws of Lebanon. All disputes that may arise shall be referred to and settled by the courts in Beirut. Now, during the process of these negotiations, which took 1 year, the issue of jurisdiction was a matter between the parties that was contested, if you like, or that was very much on the cards. And if we look at A8, page 200, is that the one?
Yes.
Is that 10th of January? Sorry, that might be the wrong reference. Like, there was an email on the 10th of January 2019, I'll take you to it and get the correct reference, where it was suggested that by my client's lawyers that jurisdiction was an issue of consideration and they did not share the thinking of the other side. And again, jurisdiction is raised as an issue. Just give me a second. Sorry, that's maybe it's a A7132. Go to that. Sorry, having had this bundle so late yesterday, some of our page references, as we've inserted them, may not be exact. We'll find it. It's A8 Exhibit FG2, which was page 6194. Is that there? It's not that one. Your Honour, I'll get you the correct references to the pages. In any event, 10th of January, and that will come back, and the 15th of January, emails suggest that jurisdiction is an issue and assumptions should not be made about jurisdiction. So jurisdiction is clearly a very live issue. And towards the end of this agreement, as it's finalised, and there's a clear email correspondence, which should be A5, I think, page 62, hopefully. Goes on. If you'll see, go down there, an email from Al-Tamimis on the 24th of December 2018, and towards the bottom of that email, the paragraph beginning, "My client showed a huge flexibility to this matter. If Mr. Sadiyyah will be insisting on his point of view, which we will see it unreasonable and justified and doesn't want to go halfway, it'll be good long years legal work for us, whereby we will go by the tricks of law, jurisdictions and executions." So already from the outset, there's a flavour between the parties where they're trying to get a deal done. We say our client is put under pressure to accept what is being said about the defendants will only accept Lebanon. And our client's clear understanding, as he's put within his witness evidence, which I can take you to at A5 and A11, is at the point that he signed and the agreement suggested it was Beirut courts, it was never his understanding that that would be an exclusive position, i.e. Beirut courts were the only courts that could hear the dispute. And if he indeed had intended that that was to be exclusive, or the parties had intended, then the same wording that was used at the outset, when it was exclusive for the DIFC, we say would have been used. If you look at A5, which is the first witness statement of Mr. Mohammed Sadiyyah, page 34, paragraph 10. Are you there, Your Honour? Your Honour, are you there?
Yes.
Yes.
Yeah.
So
Yes.
see the potted history I've just laid out to you. 7th of July, paragraph 9, governing clause of the DFC to apply exclusive jurisdiction. He agreed, paragraph 10, and then he goes on to say, it gives the history of how that changed and his understanding of paragraph 18. If we look at page 35, we conducted the main negotiations at Tamimi office in DFC until we came to resolve. I conceded to a few matters that were in dispute between us, and I conceded to dispute resolution being the courts of Beirut as a non-exclusive dispute resolution clause opposite to the initial draft settlement agreement, which has granted exclusive jurisdiction. And then he goes on to say non-exclusivity of the courts of Beirut was reflected in the final agreement. It did not occur to me it was an oversight because the words exclusive were not used. Now, why is that of importance? Well, two things. Firstly, you've been taken to lots and lots of case law about how the words exclusive doesn't have to be used, how if there is a obligation that mandates the parties to go to a certain jurisdiction, and if it's clear on its face, then that should be invoked. But you cannot, we say, detract from how this negotiation, how this contract came into place. And clearly, jurisdiction was always an issue. And clearly, on a matter of contractual interpretation, the intention of the parties must be looked at and cannot simply be waved away.
Well, but so far, I think the evidence is only that of unilateral intention. There's only evidence on the part of your client's intention. It would only be relevant, wouldn't it, if it was evidence of mutual intent?
Well,
is there any evidence of mutual intent?
Well, Your Honour, a point you made earlier about the kind of factual matrix behind this is what my client, he says, was led to understand, and that understanding came from the meetings he had with the representative to suggest that the clause of Beirut would not prevent another jurisdiction being used. And that.
But does he say what was said to induce that belief? Or does he just say he came away with that understanding?
He just says it's his understanding, and that's what the meetings, that's what was discussed in the meetings.
Well,
into the evidence.
That's not really evidence, is it, Ms. Malik? If it's going to be evidence of mutual intent, it's got to be that somebody on behalf of the other party said something from which I reasonably concluded. And there's just no evidence of that sort, is there?
There's not direct evidence of what's said between the parties at the meetings, but there's certainly direct evidence of how the contract was negotiated and what the understanding was between the parties in terms of jurisdiction. And ultimately, you'll appreciate, Your Honour, that 1 year into this agreement, and there's various emails that talk about wanting this agreement concluded, my client's position is it's signed off on the basis that he has the right not to go to the Beirut court, and just the fact that it says the Beirut courts doesn't prevent him going elsewhere. That was certainly the understanding he was given. I can't talk of what actual conversations took place, and that's not given as part of this application response, Your Honour. But it may well be an issue.
If you want to say there's mutual intent, you've got to go more than say, as a result of a conversation that I'm not going to tell you about, I formed a certain understanding, don't you?
Yes, well, that's again calling evidence of the individuals who were involved at that point to say what was understood and what was actually said between the parties. It's a point you made.
Your client says he has an understanding. It has to be based on something that was said to him, but he doesn't tell us what it is.
Not within this. No.
Well, I think that's a bit of a problem, isn't it?
Well, not necessarily in terms of if that's what if it reasonably looking at the background of the lead up, if you like, to the negotiations and all of, as I said, I'll refer you to the emails. If jurisdiction was such a hotly contested issue, then it can't be, it's not unreasonable to suggest that the position taken by my client is a correct one. If he's led to understand, and his understanding doesn't simply come from within, his understanding is with legal representatives on both sides. And in terms of what was said between them or what was said at various meetings, obviously I can't give evidence to that. But what we do know, just if you like, going backwards again, is that I'd understand my learned friend's position if this was simply an agreement, one draft, if you like, that talked about Beirut jurisdiction, talked about parties shall submit disputes to Beirut, and there hadn't been an underlying 1 year history of protracted negotiations, which actually jurisdiction was one of the key factors in those negotiations, because that must go to intention of the parties. It's not just a unilateral intention, because there's toing and froing in terms of what jurisdiction ought to be used. Even the defendants' lawyers at some stage suggested that, defendants' lawyers suggested at some stage that Lebanon would not be it wasn't their preference. So those are all, we say, important factors when looking at whether the jurisdiction clause per se is exclusive. And my friend is not helped by the reliance on Jackson, because all it does is Dicey shows that there's at least two different approaches to be taken to the intransitive and transitive obligations set out within a clause. And therefore, when the utility of such distinction is disputed, and it's disputed by Dicey, there's academic disagreement on the point. My friend relies on it to say that's, if you like, open and shut, but it's not. The reliance on the word shall, citing 411 of Joseph, is open to question, we say. So Your Honour, our position in relation to the exclusivity clause is that it's not exclusive, but even if you're not with us on that and you decide that in fact that this is an exclusive jurisdiction clause, that does not prevent you, and for reasons that are set out in our skeleton argument, and obviously judicial authority law, Karafi, and then as a third point, the forum non-convenience, which the defendant has raised as well, that even if you do have jurisdiction, you shouldn't exercise it. We say there's still an exercise to be made, even if you decide that there is an exclusive jurisdiction clause, and that's set out within our skeleton argument, Your Honour, at page 7, and that's at paragraph, starts at paragraph 15, and page of the bundle is 761 of 761, 762 of F.
Yes.
So we've set out what 5A1B firstly says, that if there is, and this is the point that deals with the underlying jurisdiction, if you like, of the DFC courts. the underlying jurisdiction of the DFC courts is that any kind of contract that's concluded in whole or in part or executed or supposed to be executed, as you know, the DFC courts can take jurisdiction. My friend, in a nutshell, has suggested that all that will ever happen was there was a contract that was partly negotiated with one meeting in the DFC, and that's not enough to bring it within this article. But with respect to my learned friend, the contract on the 4th of April 2019, and there's no dispute between the parties, that last meeting of the 4th of April 2019, which was then followed by the execution of the contract, that was concluded within the DFC with Mr. SM Al-Tamimi. So when he talks about the contract being part negotiated in the DFC, that's not correct. It was actually concluded, not executed, concluded. And if we go to the evidence on that, if we look at, again, I think it's A11, just, yeah, A11, page 636. This is Mr. Mohammed Sadiyyah's witness evidence, sworn evidence in terms, well, sworn when I say it's signed. He talks about what's said in relation to that last meeting on the 4th of April 2019, paragraph 29. Mr. Ghanem states the meeting took place on 4th April 2019. It was only in relation to the non-compete duration and the related client list. This is not correct. The meeting that took place on 4th April 19 with Mr. Tamimi at the Tamimi offices was in relation to 6 points of negotiation that Tamimi and Mr. Marta had referred to in their correspondence. One of those 6 points included dispute resolution. The point that's made by my friend in this respect is you can't have under the judicial authority law, and he decides, well, he thinks Karafi's decided wrongly, but that's not, and he concedes that's not a point for this court because Karafi applies to this court. The point is, he says that you can't have one negotiation bring you within the realm of the JL. It's not one negotiation. On his own evidence, as if it's not concluded or finalised within the DIFC, the negotiations, one negotiation doesn't matter. We say that on the face of the evidence, this contract was concluded within the DIFC, bringing it with under the JL and under the Karafi allows you to exercise that jurisdiction in any event. So the underlying jurisdiction of the DIFC, we say, is made out. In respect of, and there's lots and lots that's been made, excuse me, there's lots that's been, and you'll note that JL just says the contract only in part has to be within the DIFC, and we say it's made out. Even if you just look at that 4th of April 2019 meeting, there's various calls and emails, and we've had the if you like submissions on does it matter whether Mr. Tamimi at that stage was sat in his office in the DFC or sat at home or wherever he was conducting his business. But you can't resolve from the fact that that last meeting was at the DIFC. It was concluded at the DIFC. The defendant's point to that and the defendant's point to Karafi is simply they don't have an answer. They say it's wrongly decided and they want to appeal it. But for the purposes of this hearing, we say that's insufficient. You have the discretion, which is set out in the case law. You've seen national bonds and Talim, where it's held at, it's at page 806, it's at paragraph 63, 806 of F4, where one part of a composite transaction has been entered into inside the DFC, that would be suffice for the courts to have that jurisdiction. It's trite law. So even Mr. Tamimi's email, which was sent on the 10th of April 2019, enclosing the executed version of the agreement, was sent from the DIFC. We see that at B5674.
I think you might have misspoken there. I think you meant the execution version, not the executed version.
Execution. I beg your pardon.
Significant difference.
It's hard drawing inferences about where the emails were sent from, isn't it? Because the footer at the bottom of the emails refers to the firm being registered in the DIFC and regulated by the DFSA, irrespective of whether it was the onshore Dubai office or the DIFC office, wasn't it?
Mr. Fadi's footnotes refer to the Maze Tower and refer to don't refer to DIFC, and that there is You've heard evidence or you've heard submissions already, and my client's understanding was Maze Tower and the Central Park Towers were both DIFC. In fact, geographically and correctly, Maze Tower is not DIFC. It doesn't fall within the DIFC. The building next to it does. It's all very confusing. But the footers or the signatures, Mr. Fadi's talks of Maze Tower and Mr. Al-Tamimi's is very clear, talking of DIFC, DFSA. So, I mean, it may be a fine distinction, but the point we say, Your Honour, is that the last meeting, which in effect concluded the contract on the 4th of April, was very much at the DIFC. 6 points, we say, were being mooted at that meeting. And then the executed, not execution, the executed version of that agreement was sent from Mr. Tamimi's email, DIFC.
I think you've done it again. It was the execution version, not the execution.
It was the version prior to execution.
Yeah.
Yes, I think it's because I'm reading from my skeleton and I keep getting that wrong. The execution version was sent from DFC. But you cannot resolve from the fact, Karafi and F3 789, paragraph 60, the agreement was partly entered into, negotiated, partly agreed upon in the DIFC. And I can't see how my friend or learned friend can seek to persuade you otherwise. He seeks to say that there's just one meeting and that's not sufficient, but in fact, there's not just one meeting. That's not our position. And we say that
exactly what is there are at least, well, there are 2 meetings. There was the one prior to the engagement in 2018, yeah, and then there was the one in April 2019.
And
What's
there was
the evidence?
Phone calls.
Yes. So phone calls.
And emails emanating from Mr. Tamimi.
But we don't know where he was.
Correct. I take that point. But my point is, does it matter if the start and the end, the conclusion, and looking at the wording of the JL, the contract is in part concluded or finalised in the DFC, and nobody can seek to persuade you otherwise. That meeting of the 4th of April 2019, I think at 93 of my friend's skeleton argument, and it's just referred to in passing, simply suggests, or 98, sorry. The defendants nevertheless accept that some limited negotiation of the contract took place in the DIFC, and the claimant mischaracterises the evidence. It's not simply limited negotiation of the contract. That limited negotiation may be, I don't know, the phone calls or emails from Mr. Tamimi, but the conclusion of that contract on the 4th of April 2019 very much took place in the DIFC. And we say that brings it within the realms of the judicial authority law. If you just give me a second. Just going back, and I'm rewinding back to the position of the exclusive clause 18, Lebanon, which is the clause my learned friend relies on. Nowhere aside from within the skeleton argument by my learned friend, in the application or in evidence in support, has it been suggested that there's exclusive jurisdiction in Beirut. It's just simply saying DIFC courts don't have jurisdiction. It's not being suggested that the exclusive jurisdiction was in Beirut. So on the defendant's case, we say until Mr. Montague Smith got involved, it was a non-exclusive jurisdiction clause. That it was never pleaded that this is a exclusive jurisdiction to the Beirut courts. That's a point that's now being put forward. And there was always a substantive matters of negotiation between the parties in relation to the jurisdiction clause. And that's what my client says. So in respect of the reliance, and we've had some argument on this, in fact, I won't go into it. We talked about 5A3. My friend relies on 5A3 in his skeleton argument or enforcement of the jurisdiction agreement. It's at page 7. 5.3, the jail provides a court of instance, first of instance, may hear and determine civil or commercial claims falling within its jurisdiction if the parties agree in writing to submit to the jurisdiction of another court, but such court dismisses the claim. So what we say, and you'll see in our skeleton argument, is that reliance is misconceived. 90 of Karafi, F3793 of the bundle before you, sets out that this Article 5A3 is aimed at a situation where there's a dispute between the parties that would otherwise fall within the exclusive jurisdiction of the DIFC courts, and one or both of the parties have not invoked the DIFC jurisdiction and gone straight to a foreign court. Just to be clear, what the claimant's case is, we're not saying the DIFC courts have exclusive jurisdiction in disputes. What we're saying is that the Lebanese courts don't hold that exclusive jurisdiction, and therefore it's open for us to bring it to the DIFC courts. So if there's a mischaracterization of our position, it's simply incorrect. And also, just to make it clear, there's a lot of criticism that's made, and I'll come on to look at the current situation in Lebanon in due course when we look at foreign non-convenience. But our client's position is that currently, as the situation stands in Lebanon, it falls within those exceptional circumstances. Currently, the judiciary, currently what's going on, falls within those circumstances where a fair trial, just inconvenience, all of those factors that we look at within the case law, which departs from enforcing if you like, a jurisdiction clause or looking at where there would be the most appropriate forum for a matter to be heard, falls outside Lebanon, even if you feel that it's an exclusive law.
Do you accept that I can only look at matters that were not foreseeable by the parties at the time? Let's assume that I conclude, contrary to your argument, that it is an exclusive jurisdiction clause. Do you accept that in that event, I could only exercise a discretion, which Mr. Montague-Smith says I don't have, but but if I could only exercise the discretion having regard to matters that were not foreseeable at the time the clause was entered into?
Yes, and we say that because the clause was entered into 4th of April 2019. There was a significant deterioration in October 2019 with the bomb blast, COVID, all of those factors. Those were not foreseeable at the time that the contract was entered into. So it's not good enough for Mr. Montague-Smith to simply say the situation's not changed, and we'll come on to look at once you've heard our position on the expert.
That's the point of principle is what I wanted to know, and we can come to the facts or the evidence at least in due course. Thank you.
The point, so it doesn't deal with the fact that the agreement, and I'm going to hopefully use the right word this time, the executed agreement, or the version of the agreement that's signed by the parties, shall we say, April 2019. There is a huge wholesale change worldwide known in October 2019 with the bomb blast in in Beirut, and the fall, if you like, thereon with the collapse of the economy, all kinds of factors that, whatever the position with the expert evidence, and I'll come to address you on it, the objective material that's relied on by both experts, i.e. the reports, the NGO reports, the World Bank reports, that's evidence that's available in the public domain. So whatever we want to say about the expertise of the experts, we can't resolve from the fact that everybody knows, and it's publicly available information, and it's in the bundle before you, the situation in Lebanon in terms of not only economically, the judiciary, backlog of cases, how things are being dealt with. So again, clever academic arguments are being made as to, well, the situation is exactly the same. It's not. And we don't need expert evidence necessarily, Your Honour, I'm going to suggest to know that it's not. We don't. It's helpful, it's there, it assists the court and it assists the parties. But it's a well-known fact what's going on in Lebanon. And my learned friend's position is, well, it doesn't go anywhere near taking us to the position we need to be in to show that there's exceptional circumstances. It absolutely does. Because even the whole arguments, and we've had academic arguments of what happens, for example, with the Lebanese currency and how it would be applied, and would it be paid in US dollars, would they be paid at the peg of US dollars, which, by the way, according to their own expert, and I'll take you to his report, even if you don't allow ours, he agrees with what we say. It's not settled law, that's the point. And the second point is that the currency and the devaluation of the currency and where we are at today, it's not been there in decades. There are issues in Lebanon today that it hasn't faced in decades of its political or otherwise legal issues. And for my learned friend to suggest, well, actually, that's the more appropriate forum for this case to be heard, it has to be demonstrably, we say, incorrect, given vis-a-vis the DIFC's ability to deal with this matter and the connection, we say, the justice fairness that could be given, and what will happen in Lebanon. And those are important factors, we say, that need to be taken into account, even if you decide that it's an exclusive jurisdiction clause, and whether you decide to disregard an exclusive jurisdiction clause. We know, again, it's Trite Authority, Donoghue and Armco, it's G4921, it's referred to paragraph 25. I can take you to the authorities if you'd like me to, but they're Trite authorities, Your Honour, and I don't think you need to see them. If you would like to, I'll take you to the paragraphs. But they're set out within our skeleton argument. Reference is made to the decision in Eleftheria, the matters that are properly regarded by the courts when deciding whether to disregard an exclusive jurisdiction agreement. So this is on the premise that you find there is an exclusive jurisdiction agreement. So the expense of the trial, the convenience, where is everybody situated? There's one defendant situated in Lebanon. Lawyers, witnesses, everybody's here. The law, we can always apply Lebanese law here. Where are either party connected and how closely? Is it genuinely a desire to have a trial elsewhere, or is it procedural advantages? And I'm going to make this point, Your Honour. This case from the outset has been, and my friend says, or my learned friend will no doubt say, oh, they're not technical points we take. There's a point taken at everything. And that's because we say it's clear that the defendants have a overriding, if you like, agenda not to have this matter heard. At the outset, Tamimi's refused to accept jurisdiction. They're not instructed, they're acting now. Service, both in Lebanon and in Singapore, has been, and we'll come to look at how my co-counsel or Wassel and Wassel did their due diligence, if you like, before they served, and what our position is on 413 of the Lebanese Code. But service is being attacked, and jurisdiction, and it's being suggested, well, actually, Lebanon is the correct place to hear this, and it's okay. It takes 3 years. We've not really moved on much from where the position was before the when the contract was agreed. And we say that's just indicative, or just a pattern of this matter, or the position taken by the defendants for this matter, and the actual substance of this matter not to be heard. There's lots of technical points that keep being made over and over again. And the reality is it's a straightforward, and nobody's got into the merits, and I appreciate that, but it's a straightforward monetary debt. You've seen the global settlement agreement. You've seen what was to be paid when. You've seen there's also reference to, and it's referred to my client's witness evidence, that there's reassurances that we are going to honour our promise, we are going to pay you. So it's a monetary debt that's not being paid, and every obstacle, we say, is being attempted very cleverly by Mr. Montague Smith, one of the leaders we know in this jurisdiction, to try and prevent this matter from being heard. And we say, well, it should properly be heard in the DIFC. So we say that in terms of Clause 18, if you find it is an exclusive jurisdiction, there's a number of factors that weigh against giving it the effect that the defendants want you to give it. Not least how the agreement was negotiated. Lawyers located in the DIFC, the only defendant's only non-expert evidence is from one of those lawyers, Mr. Sadiyyah, who's in Dubai onshore, if you like, Mays Tower. We haven't heard from Mr. S.M. Al-Tamimi. I'm sure his evidence would be relevant if this matter were to go to trial.
Why would it be relevant, Ms. Malik?
Well, just in terms of what the position was, or his understanding was in relation to, or what conversations took place in relation to the himself and the defendant, to shed clarity on the claimant, to shed clarity on what the parties discussed both at the outset in March 2018 and thereafter in terms of when the matters were negotiated or concluded. And he may recollect, because we had Mr. Fadi saying, oh, the 23rd of April 2018 meeting was nothing to do with anything until evidence was shown, and then rejig his memory.
I should have been a bit more explicit. There will be a trial in the DIFC if you overcome the jurisdictional issue. Correct. We don't know what the issues would be in that trial, because there's been no joinder of issue in relation to the merits. So that's the basis upon how do we know that Mr. Tamimi would be a relevant witness when we don't know what the issues in the trial would be.
Well, correct. I take that point, Your Honour. In terms of the relevance of his evidence, one would have thought it would have been more so for this application for him to say, given a lot has been said about his involvement, and we're hearing from Mr. Fadli Ghanem what he said. I take the point you make in terms of the issues between the parties, but certainly his evidence would have been, we say, relevant here and would have assisted the court, but that's not been given. But going back to why, even if it's an exclusive jurisdiction clause, the factors that weigh in our favour, in our client's favour, for you not to give effect to that is, as was the position in Karafi, again, it's paragraph 119, any expert evidence, any positions on Lebanese law, all of those factors can easily be accommodated within the DIFC courts. The choice of Lebanese law can be given effect. There's a concession, and this is at B567, well, it's set out in the particulars of claim, and it's referred to in an exhibit, that they owe the claimant the money sought. There is an email that says, yes, we owe you what, and we can take you to that. I'll just get the correct reference from my junior. It's at the particulars of claim B5670. So we just say the jurisdictional challenge here just appears to be a simple attempt to put off delay of a payment. And the situation in the Lebanese courts means that our client, no doubt, would be prejudiced by having to sue in those courts. Now,
well, as compared to, well, you're going to come to the evidence about the situation in the Lebanon in due course, are you?
Yeah, correct.
Yeah, all right. Well, let's leave it till then.
Okay. You want me to address you, Your Honour? Again, it's in our Scaliton argument that the Court of Appeal case you're aware of, Protivita, I'm probably saying it wrong, member for Middle East versus Al Mojul, F5 begins at 810. DIFC courts in relation to the forum non-convenience point, those matters have already been hashed in that case, and they followed the English doctrine in that case in Spiliada. So what's interesting here is, again, the defendants don't even seek for you to stay these proceedings in favour of Beirut or otherwise. They're saying just strike them out, which is quite draconian and quite unusual, because usually in proceedings of this nature, there's a request for a stay of proceedings in favour of another jurisdiction. And in Spiliada, the basic principle is a stay will only be granted on the grounds of forum non-convenience where the court is satisfied there is some other available forum having competent jurisdiction, which is a more appropriate forum, and in which the case may be tried more suitably. I understand my learned friend's position, which at the outset says there's a clear exclusive clause, so we don't need to get into this because we only need to look at this if there's not a clear exclusive clause. But we say even if there is a clear exclusive clause, these are all factors that you take into account when you're exercising a jurisdiction.
What's the authority for the proposition that the normal FNC criteria apply if there is an exclusive jurisdiction clause?
Sorry, if there's an exclusive jurisdiction clause, you can still look at forum non-convenience.
Well, the normal principles of forum non-convenience arise when there are two or more courts, each with jurisdiction, and one party commences in a particular court and the other party seeks a stay on the basis that another court is manifestly more convenient. Yeah. That's when those principles apply. Now, you're saying that I can apply those even if I conclude that's an exclusive jurisdiction clause. And I'm just asking, what is the authority for that proposition?
Donahue and Armco and Eleftheria. Donahue and Armco. It's at paragraph 28 of our witness evidence. Sorry, not witness evidence. Our Scaliton argument, paragraph 28, page 10. Even if clause 18 did grant exclusive jurisdiction to the Lebanese courts, there are strong effects for not giving to it. The English House of Lords in Donahue, paragraph 25, listed the matters which might properly be regarded when deciding to disregard an exclusive jurisdiction agreement. So the case law allows you to do that. And even in fact, hopefully you'll get the dicey commentary. Even within that commentary, and I'm sure it must say in Jackson, there is proposition, or there's certainly academic commentary that says that even if there is exclusive jurisdiction clause, there's a discretion that's retained to not apply that clause. It's a question of construction. It's a question of what the parties intended. It's a question of looking at the whole kind of contractual background. It's not just a matter of case law. So again, I'm reading from, and I appreciate you don't have it in front of you. from Dicey, and it's for my learned friends, reference 12116. The legal effect of a valid jurisdiction clause. As a general rule, but subject to important exceptions, English courts will give effect to choice of jurisdiction. If England is the chosen forum, the jurisdiction clause will be effected to confer jurisdiction. In certain circumstances, courts have discretion not to exercise it. They have a discretion not to exercise, and the case law that sets that out, we say, is set out within our skeleton argument, and the factors that you need to look at are set out within the skeleton argument, also at paragraph 28. So dealing with those and dealing with going back to the forum non-convenience point, that's at 31 and 11 of our page 11 of our skeleton argument. The defendants have to, if we look at the forum non-convenience, satisfy this court that there's another available forum which prima facie is more appropriate for the trial of this action. And they say the Lebanese courts are prima facie more appropriate. They're the natural forum, and they have the most real and substantial connection. And that's obviously if you're not with them on the exclusivity point. And they're saying that, you know, Lebanese law applies. Well, we can apply that in the DFC courts. The DFC courts can give effect to that choice of law. And the factors we set out at 35 and 36 set out why we say the DFC courts would be the more appropriate forum. Agreement drafted outside Lebanon, agreement between 3 parties, only one of those is located in Lebanon. Payment needs to be made in US dollars to the claimant's account in Sharjah. The defendant's position appears to be all relevant witnesses and documents are likely to be located in Lebanon. That's at Mr. Ghanem's witness statement. And we say that that's not correct. They can't simply show Lebanon has the most kind of real and substantial connection. We say even if it is correct, the circumstance of this case required the dispute be resolved in the DFC courts. And again, for the factors that we've already given. This claim is not a claim about the business affairs of the defendant. It's a straightforward monetary claim. We haven't gone into the merits, but again, we have email evidence that suggests there is really no issue in terms of, you know, there's a concession that payment needs to be made. The stability of the DIFC vis-a-vis Lebanon, the DFC courts operating efficiently, unlike Lebanon, are a relevant factor and an important factor. And what I'm going to do, we've heard much, and I will address you now on the expert evidence, if you like, of both. Now, the first criticism that's made is we didn't apply, as we ought to have expert evidence adduced, and it was sent as part of the particulars of claim, if you like, and then the actual independence of that expert is a question, or credibility issues made. In relation to that point, Your Honour, it is correct that an application was not made at the time for expert evidence to be adduced in the particulars of claim. These were unusual circumstances where the particulars of claim, if you like, second-guessing or prefacing that jurisdiction would be a huge issue, given the nature of the negotiations between the parties and the lead-up and the emails. At that stage, co-counsel took the view that this would be the most, if you like, helpful way to plead the pleadings. But in terms of the, and again, I'll come to say that even if you don't accept the expert or don't accept or allow the evidence to be adduced on both sides, it can only assist the court. Certainly the objective evidence that's referred to by both can only assist the court in the arguments that are made. But just to address some of the points made by my learned friend, if we look at B6693, what you'll see in the legal opinion that's adduced by the claimant's expert, he does this from his own law offices. Shihad Malouf's Office for Legal Consultation 693 at the request of Wassel and Wassel. My learned friend has characterized the relationship between the two as managing partner, if you like, and employee. That's simply not correct. He quite rightly says, and it goes on at page 69, he declares, if you like, his interest and sets out that 695 that I have worked or work as of counsel for Wassell & Wassell. He's not employed by them. He's instructed by them to do things from time to time. But the same way we instruct experts, and we can use the same experts from time to time. But to suggest he's employed...
Does he say who he was employed by?
Well, he's at page 693. He sets out specialization, Lebanese law, upon request, Wassell & Wassell, prepared for the DIFC, attorney, Shehad Malouf's office for legal consultations. And then he goes on at 694 to set out, I own my own law firm, which he does in Lebanon. And he works as of counsel. As an external of counsel, he prepares or gives reports or otherwise as is required to Wassell & Wassell. He's not employed by Wassell & Wassell. And he's in fact referred to that, whereas my friend seems to or suggests that in fact attacks his credibility because he's totally conflicted Mr. Mohammed Abu Wassel as his managing partner. It's not correct. He's declared at 6958, I declare I work as a of counsel in accordance with an of counsel agreement, but the scope of my work is to provide the present legal opinion. There's no conflict of interest. He works in a separate law firm. He has an association with Wassell & Wassell where he provides of counsel opinions, the same way you or I may instruct experts, and we may instruct the same expert sometimes over and over again or time and time again to provide opinions. It doesn't mean that he's under the direction, control, or there's some kind of, he has to say what's being said or what Mr. Abu Wassel wants him to say, because he's made that clear in his conflict of interest declaration. He's made that position clear of what his background is. So I just say that because there seems to be some misconstruction of his position. And also, I think my learned friend somewhere said, well, he doesn't know anything apart from criminal defence, which is not correct, because if we look at 6955, paragraph 5, I have legal experience in commercial and corporate law, administrative, civil and penal law, where I provide legal advice to many companies in various commercial, financial, real estate, bankruptcy issues, and I represent many of these companies before Lebanese courts and abroad. And just to clarify as well, Wassell & Wassell is not a Lebanese firm. I think somebody said that at the outset. They're Jordanian. Mr. Abu Wassel's Jordanian, but just to, not that it's neither here or there, but just to make that distinction. So he has his own law firm. He acts as of counsel to Wassell & Wassell, and he was asked to prepare an opinion and sets out, this is my opinion. That's what that says. And in fact, it's useful, we say, subject to you allowing it to be before you, because we say all it can do is assist you. And the other side's legal opinion also can assist you, and we'll take you, or I'll certainly go to their opinion, because we say the two experts are not really at divergence with each other in respect to the situation or the current situation in Lebanon. And to that extent, it may assist if I take you firstly to, and I'll probably apologise, pronounce his name wrongly. Is it Mr. Shaheen, his expert evidence. If you just give me a second. Okay. If we go, Your Honour, E1 737, this starts the expert report of the defendant. Seven three seven. Is that not right? No. Okay. Just we can't get the right one up on the. Where's the printed copy? Ah, okay.
Perhaps I can help. What are you looking for?
No, I have it. It's just I have a print. The pagination isn't the same as I think it's. Is it 247? His report. Does his expert report start at 247? Yeah, it wasn't 637. 247 at A9. A9 of the bundle. 247 starts the expert report of Mr. Shaheen. And we see at paragraph 12, 249, Your Honour.
Yes.
I agree with the statement made by Mr. Malouf. In paragraph 33, it stated Lebanon has historically suffered from sluggish trials, some taking several decades to resolve. I also agree with the assertion on average trials last for 3 years and 4 years in Mount Lebanon. He goes on, and why are all these important? I'm going to show you where there is, if you like, agreement between the parties or agreement between the two experts of the parties that suggest Lebanon really wouldn't be the correct or appropriate forum for this.
But in April 2019, the parties agreed that the courts of Lebanon could have jurisdiction on Mr. Montague Smith's case, had exclusive jurisdiction.
Correct.
So the evidence you're taking me to now doesn't suggest that there's been any material change in delay since April 2019, does it?
If you go to 21, even of their report, which is at page 251, we start talking about October 2019, after the agreement is executed. So we see this civil protest triggered by planned taxes. These protests expand into countrywide condemnation of the rules, stagnation of economy, unemployment, corruption, endemic corruption in the public sector, failures of government, acute financial and banking crisis. None of that was foreseeable. None of that was on the cards, if you like, in April 2019.
Question for the court is, what impact has that had?
Yeah. And I'm coming on.
All right.
Sorry. Sorry.
Against the contingency that the exclusive jurisdiction point is decided against you, it would be helpful to me if you could identify matters that you say were not foreseeable in April 2019, insofar as, and I understand, of course, the explosion was not foreseeable in April 2019, but the question I'm looking for on it, and I don't see it readily in the evidence, is what the impact of the explosion was upon the progress of cases through Lebanon's courts. You can imagine it wouldn't have been positive. But I didn't spot, when I was reading the evidence earlier, I didn't spot anybody saying, as a result of the explosion and the consequential governmental instability and the economic instability that followed, the lag time, the delay in running cases through the court went from 3 years to 7 years. Nobody said that, as best as I can see. The evidence, I have the impression, and this is why I'm really throwing down the gauntlet to you, Ms. Malik, to disabuse me of it. The impression I have is the situation is bad, but it's always been bad. But if that's the wrong impression, please tell me and point me to the evidence to the contrary.
Yeah. So first, I'll go to both of the reports. Firstly, in terms of the explosion, 252 of their report, paragraph 23 and 24, not only deal with the explosion, but deal with the COVID pandemic, right? So we know, and worldwide this happened, the COVID pandemic restricted activity of courts, obviously, that wasn't foreseeable at the time. And we see that release hearings for criminal courts and urgent matters were excluded from the scope of suspension. So these matters...
But again, just pausing there, the situation, of course, has changed significantly in relation to the pandemic in different parts of the world. Is there any evidence on what is the lingering impact of the pandemic in Lebanon? Because in a lot of parts of the world, including the part of the world in which I am, it's having not a great deal of continuing impact.
Yeah. Well, what we see is at 701 of page 701, that's our report, if you like, paragraph 34 talks about the pandemic and the lockdown and then the consequent effects of that. So from March 2020 to March 21, public administration of courts were closed for 204 days so that was until March 21, which amounted to 57% of the year, suspension of all trial hearings in civil and commercial courts across Lebanon, and consequently precluded courts from deciding pending cases for the awaited judgment.
That's my question is, what's the situation now?
Well,
is there any evidence that the pandemic is having any continuing impact on the prosecution of litigation in the Lebanon?
Your Honour, in terms of what's set out in this report, is if we have 57% of the year nothing is being heard, the backlog of cases, forget the ones that are now being brought to the courts, there's a huge backlog of cases.
But where does Mr. Malouf say that? Because Mr. Shaheen, I think, says, and he goes to data, to say that the clearance rate, which is something I know a bit about because judges talk a lot about clearance rates all the time. It's part of the KPIs, but the clearance rate has remained relatively constant.
Well, the point that the point I think that's made by Mr. Shaheen and what he relies on is, oh, there's more cases that are dealt with than that are brought. That's his position. But the question is, if cases are dealt with, more cases are dealt with than that are brought, are they dealt with efficiently and properly? And that's the key to get the correct kind of justice, or if it's the appropriate forum for that matter to be heard. It doesn't matter if you can get through 10 cases a day, for example, clearing a backlog, if you're not giving the correct attention or there's interference in the way you're dealing with those cases.
Well, now I am a little confused, because I thought your case was based on delay, but are you saying that it's based upon the quality of the justice? I understand the points you make about political interference. We'll come onto that in due course. But are you saying that it's the quality of justice in the Lebanon that has deteriorated?
I think the position that's relied on is both. It's excessive. It's not just delay. It's excessive delay and the quality of justice. And that's why I will take you against.
Well, where's the evidence that the quality of justice has deteriorated since April 2010?
Well, first, if we again go to 701 of our report, paragraph 35, and this talks now of the COVID lockdowns once they're lifted. So we're now into March 2021. What happens thereafter? The Beirut Bar Association goes into strike from May until September 2021, paralyzing the functioning of courts once again, more backlog and more delays. You'll see that at paragraph 35. Court staff go into general strike owing to the deterioration. This is now economic consideration, but has an impact on the legal process in terms of, what's happening, if you like, on the ground in the courts. Salaries, living conditions, inability to attend workplaces because they couldn't procure fuel for cars. So the 37, he goes on to say, page 702, the aforementioned circumstances and reasons have deeply disrupted the function of courts and continue to do so. Depression among judges, court staff and lawyers, a real threat to justice in Lebanon. So that's his position in terms of what's happened, not only the explosion, the pandemic, the after effects of the pandemic, the economic situation. There's a snowball effect. It can't be looked at in isolation. And Your Honour, whilst I respect that in certain of our worlds, if you like, the pandemic effect is now diminishing. We have a changed world. We have these remote hearings that may well stay. But in Lebanon, that's not the position. So it's the cumulative factor, and it is set out. We cannot say that the situation was foreseeable and it's exactly the same as it was before. That's incorrect on the evidence before you. And even going to Mr. Shaheen's report, and I'm going to take you to various references. We have paragraph 27. Paragraph 27, 252 of the bundle.
Yes.
The current financial and economic crisis led to a decrease in salary of judges, multiple strikes and shortage of energy, and we've heard about those strikes in our experts report, have led to postponement of hearings and affected working hours. So not only the pandemic, not only the explosion, but because of the situation in Lebanon, we have a backlog and ongoing postponement of hearings owing to the cuts in salary, owing to people not turning up to work. We see as close as March 2022, this is their paragraph 28, a group of judges went on strike in protest of the situation of the judiciary. These are ongoing effects, not only that were not foreseeable in April 2019. The situation has, we say, dramatically changed. The strike excluded only urgent matters and released hearings. He goes on to say, it should be noted, all judges didn't go on strike. Well, we'd be surprised if every single judge went on strike. I mean, it may well happen. I haven't heard of judges on strike in a country, every single judge on strike. But I mean, to suggest that not all of them didn't go on, I don't think is really helpful. Several judges did not join the ranks. Big deal. The strike might delay proceedings. It doesn't affect the right to bring a claim. So what he's in effect saying, without saying it, is the strike has had effects. You can still bring your claim, whether it's going to be dealt with. Still, from start to finish, we're looking at a 3-year once you get started. But when do we get started? According to both experts, there is delay. There's a backlog. And even for the cases to be registered and get started, it's not going to happen. And once they do happen, there's at least a 3-year, if not decades of litigation. He goes on to say, 29.6, page 253. This is all their report. Although the strike of the Beirut Bar Association contributed to delay in proceedings where an attorney admitted to Beirut Bar Association, this went on for months, we know, these delays were not caused by a dysfunction of the court system, but by the decision of the attorney. So he's separating, saying the courts work, but the lawyers who are supposed to work the courts decided not to help the courts work by going on strike. That's in effect what 29.6 says. So it's not the Lebanese court system, it's the fact that the players in the Lebanese court system decided to go, and therefore the natural impact that has had is that delay, which wasn't foreseeable in April 2019. But my learned friend's position is, no, we're in exactly the same position we were in when this contract was signed. 31 of their own report, page 254. It follows that the events described above did not prevent the courts from conducting proceedings. The functioning of Lebanese courts described does not constitute a significant deviation during the period that preceded. What does that say? Does that say that they're functioning properly? Does that just say that the functioning of that there is a deviation? It's not massive, but it's happened. Yet when we take the whole background of the protests, the delays, the economic situation, the court staff not turning up, but we can still deal with matters. We're still functioning. That, in essence, is what he seems to be saying. And, Your Honour, I think we can't depart from the fact that you have to look at whether a proper forum, an appropriate forum where proper justice will be served is in fact Lebanon, given that history, and they are saying that. So it's not correct to say we are in the same position, the status quo of April 2019. It's in fact incorrect. 49.2 of his report, which is interesting, at page 258. It is not reasonable to assume all politicians interfere with cases. So it's reasonable to assume that some politicians interfere with cases. I mean, the wording is, he's saying it without saying it. It is not reasonable to assume that all politicians interfere with cases pending before the courts, or that all judges in Lebanon are under the influence of a politician. And let's just put that into the context of DFC. Would we say it's not reasonable to assume that all politicians in Dubai or in DFC interfere with DFC cases, or that all judges in the DFC are under the influence of a politician? We wouldn't. The position would be none are. Here he's saying, well, not everybody is, but some are. That's his position. And second, it has been reported political interference does not occur often in civil cases. So it occurs. It just doesn't occur often. So there's no, he goes on to say there's no tangible evidence that the outcome of civil cases where no national interest is involved, and it's unlikely in this case that it'd be of interest. He's not saying it definitely won't be. So no, it's unlikely that this case is going to attract that kind of interest. It's not very likely as the case involves. He's not even going so far in his expert opinion to say this case is not going to attract any kind of adverse consequences or adverse interference. He's not saying that because he can't say that. So
there's no evidence that this level of interference has altered since April 2019, is there?
There's not evidence of the interference, the delay, and the actual functioning of the court system. There's lots of evidence in both reports of how that's fallen down. But the political.
So if it's an exclusive jurisdiction clause, then the point you're now making won't help you.
Sorry.
If it's an exclusive jurisdiction clause, the point you're now making won't help you, because if there was political interference in April 2019, that was the time at which the parties elected to confer exclusive jurisdiction upon the courts of Lebanon. Yeah.
But it's a point that will assist if it's looked at the realm. I appreciate that if it was the only point that was being made, that it's exactly the same position as it was in April 19. But it's one position that when factored into the whole holistic view of how Lebanon, if you like, would conduct these proceedings, or what kind of chance of a proper trial they would have in Lebanon, it's relevant. So I take your point that it's not helpful in terms of, well, if that was a position in April 19, there was political interference, it's still political interference now, it doesn't help you. But it does when it's looked at in the realm of all the other, if you like, adverse consequences, because that political interference, we say, that is exacerbated by all the other negative connotations that have since April 18, unfortunately, been the way in Lebanon. So that's just dealing with the delay and in Lebanon and whether a proper trial, effective, appropriate forum is Lebanon and whether it's a correct forum to be used. And just dealing quickly with that point of the exchange and the monetary exchange. It's not settled case law of what Lebanese courts will do in respect of payment in a non-kind of national currency. And both experts say that the case law is not settled on the matter. There's divergent issues. And the problem we face is if this matter is heard in Lebanon, and when it comes, and remember the clause also talks of enforcement, our client seeks to lose, and looking at the market rate and looking at the official rates, about 95% of the contract value, i.e. 95% of the money owed. That's not going to happen in the DIC. He's going to be paid in dollars, which are not pegged to this artificial kind of Lebanon.
What do you say about the proposition that Mr. Malouf has misconceived the legal arrangements in the Lebanon and that the matters to which he referred only apply to domestic contracts, not to international contracts?
That's not settled law even on their own proposition. If we look at...
I don't think that's right. Isn't that the case that Mr. Shaheen says the position is settled in relation to international contracts, but not settled in relation to domestic contracts?
That's not my... That's his, as I understand, that's his opinion. I mean, I'm sure if I'm wrong, my learned friend will take me to where it's...
So page 270, paragraph 97. And I took you page 500, he sets out the reasons why and makes clear that it is settled at court of cassation level.
That's his opinion. That's simply his opinion.
Yes. But Mr. Malouf doesn't address the distinction between international and domestic law, does he? On domestic contracts, I'm sorry.
Do Lebanese law that allows national courts to address? Just give me a second. Not us. At 3.7, how do Lebanese courts deal with debts denominated in USD? Do the courts allow you to be paid in LBP at what exchange rate? So he deals with that at, you just give me a second. Page 705. After the, Your Honour, at 705, he sets out the issue in relation to debts that are denominated in the USD and how those affected vis-a-vis the Lebanese pound. And he does quite a long kind of analysis on that. The question you asked...
He doesn't address the distinction that Mr. Shaheen draws between the law pertaining to international contracts and the law pertaining to domestic contracts, does he?
He addresses just simply the monetary value, if you like. He addresses what the position being taken. But Mr. Shaheen's point, and I will go to it, we say is just simply his. It's his opinion. It's not correct. It's not to suggest that that's exactly what would happen in all foreign contracts. He can't say that that's how the Lebanese courts are dealing with every single contract that comes to it. That's an international flavour.
Well, he does say that it is settled law by the Court of Cassation that where there is an international contract denominated in a foreign currency, the court will order that the parties perform their bargain and pay in that currency, doesn't he? That's how I read his report.
I'm just going to go to, sorry, Mr. Montague-Smith, can you just take me to that reference again, just so I can refresh my memory? I can't hear you.
Yeah, certainly have to be of service. You can see it at page 270 of the bundle, paragraphs 97 and following. And you'll see the reference for your Lordship's note to the various authorities that are cited at all Court of Cassation authorities. They're in the bundle. I mean, we can go through them if we need to. But you'll see that at tab 83. So the issue arises in relation to domestic contracts because it hasn't been determined at Court of Cassation level. But for international contracts, you've got this series of cassation decisions. So that's the point.
Well, Your Honour, my understanding, and it's a matter for you, is that it's not settled and it's his theory. That's the position I'm told, and that's the position I'm instructed, that that's simply what he believes, and it's theory in terms of what the international and domestic contracts and how the courts would deal with that.
Right.
And then I think that leads us to service.
Yes.
And what happens with service. Now you have, from my instructing solicitors, a very detailed background, which I know my learned friend has taken us to, Mr. Abu Wassel's statement, and I'll take you to that as well, which sets out the position and how he came to serve where he did serve. Firstly, dealing with the service in Singapore. You'll see that the website address given and the LinkedIn address given, so the official communication, he followed that, and he went online to find out where they were based, and he served at that. Now, if they've given the wrong information on their own website, my client's now being, or we're being criticised for that. So the defendants contend service in Singapore and Lebanon, we'll deal with Singapore first, is not valid. And they say that's because it wasn't effected in the right place. Now, Mr. Mohammed Abu Wassel's statement, can we just go to it on screen, please? Sets out the position of, and takes you through exactly what he did. That the first defendant's office address is publicly listed on its official website and its LinkedIn page as a sorry, we're looking at the Singapore one. Singapore, yeah. Paragraph 7 to 10 of his statement, it's page what? 79, A79. Yeah. So finding the address for the Singapore entity, he looks at the global settlement agreement. He finds their address online. It's the only address that's given to them. He goes onto their website. It's the same address. He finds them on a public domain called OpenGovSG that lists them at the same address he'd found on the official website at 111 North Bridge Road.
What is that to the proposition that he was looking at the wrong entity?
It's the correct entity. Khatib Alami Ptd Limited. That's my understanding. With the wrong address.
Isn't it partners? Isn't there? Aren't there two entities? One with the word partners in it, and the other without. I got that wrong.
I think that's right. Your Honour, I may need just 5 minutes just to take instructions from Mr. Abu Wassel on point, but my understanding was that the error occurred because of their own misconstruction of where they're based. It's not that the wrong party was served. That's not my understanding. Khatib and Alami on their professional networking website, LinkedIn, they found the publicly listed address for the Singapore office was the same listed on the Khatib and Alami website for Singapore, which was 1302 Peninsula Plaza. So he relied on those official addresses, which are the only addresses that are given publicly for the party.
Right.
If I may, just have 5 minutes before we have a reply,
yes.
And I'll double check that point.
Yes, all right. We'll take a 5-minute break now. We'll resume then at, let's resume at 20 past the hour, shall we? It's a little longer than 5. All right, we'll resume at 20 past the hour. Thank you.
Thank you, Your Honour.
Yes, Ms. Malik.
Thank you. I took instructions. This appears to have happened. So the Khatib, once you look at their website, I'm going to call them Khatib and Alami, and once you look at their public listing or their LinkedIn, only one address is given, and that's the address that was served, and that's the 1302 Peninsula Plaza address.
But that's not the address given for the name of the entity that is a party to these proceedings, is it?
Well, the at page 89, it talks of PTE Limited. On ours, it talks of PTD Limited. But I think, in essence, what's happened is when my instructing solicitors have gone online to get an address for Khatib in Singapore, the official address that's given on their website, which we've just looked at, on their LinkedIn, is that one of 1302, which was served. And a distinction's not therein made of international and partners limited. And I think therein lies the confusion, because the outward perception publicly for Khatib and Alami in Singapore is that it's a 1302, and that distinction on the publicly available websites isn't made. So if my learned friend's position, or the position is, well, you've served the wrong entity, you've served Khatib and Alami International PTE Limited, who are 1302, as opposed to Khatib and Alami Partners you've served International, as opposed to Khatib and Alami's Partners, which are 2403. Your Honour, as I've spoken to Mr. Abu Wassel, and as we've checked the information that's available online, the only address that's given, both within their website and on their LinkedIn, is the 1302 address. And that's whether you type in Khatib and Alami, you type in Khatib and Alami Partners, you type in Khatib and Alami International, Khatib and Alami, there may well be distinctions between their registered address, their service address. I'm not aware and I can't say, but that's the address that's given on the public forums for service, and that's why they were served there. And I'm sure if you did your own check, you would see that. So the point that's being taken by my learned friend, we say is it's demonstrable that the registered address, or the public address that's given, putting in Khatib and Alami Singapore, is the address that was served. So that's our position on that. In relation to the service in Lebanon, and we've been taken to Article 413, which suggests that that's not been served properly because it applies to, for example, service outside the jurisdiction, so that can be done by way of postal or courier means, if you like. The position that's set out in our skeleton argument is the position that's adopted, which is that the reverse of that is where there's extraterritorial jurisdiction, extraterritorial service, i.e. we are serving outside of Lebanon into Lebanon, we're not serving within Lebanon.
Why would that apply? I just can't see any logic in that at all. I can understand why the law would provide how you serve Lebanese process outside Lebanon, but surely the law with respect to service in Lebanon would be the domestic law. You wouldn't draw an inference from the arrangements made for service overseas, and what's put against you is the domestic law identifies the classes of persons who can legitimately serve process, and a courier is not amongst those classes. So right. What do you say to that?
The position is exactly as you outlined earlier. It's the inference that's made that if one can, with domestic service is different, where we say the domestic Lebanese Code of Civil Procedure applies, but where
but service within the Lebanon. So there's only one regime for service in the Lebanon, and that is the domestic law of the Lebanon. You make arrangements for service overseas because there are 187 other countries in which service might be affected. So you specify one means that is effective wherever service is carried out. But within the Lebanon,
I think the point that's made, sorry, I don't mean to interject.
No, I obviously didn't make the point as well as I could have. But I just don't understand why you draw an inference about how process should be served within the Lebanon from a law that provides how it should be served outside the Lebanon.
Your Honour, I understand that proposition, and my instruction and others set out within our skeleton that the reverse is what's been relied upon as an inference, that if it's an extraterritorial kind of service, if you like, into Lebanon, and I appreciate the point you make of, well, the 413 deals with when you're serving outside of Lebanon, but if the same applies, if you like, serving extraterritorial into Lebanon, then guaranteed mail from a foreign country or jurisdiction, the inference was taken that was sufficient. And that's, I think, as far as I can take that point on service. Your Honour, just before we wrap up, one point, and it's correct, I think I need to make, and we talked about the settled law or otherwise in terms of, international contracts, domestic contracts, what rates would be, what would be applied, USD or Lebanese pounds. And I know the expert report on the other side suggests that the Court of Cassation or otherwise has settled the law for international transactions. The effect is the same. Because of the artificial peg, or because of the artificial rates that are being used in Lebanon, even if the international contract was given effect in US dollars, what my client will realize in real terms is when you peg it against the lira, against the Lebanese pounds, is going to have the same effect unless it's paid in dollars.
I don't understand that, because if the money is paid in US dollars, it'll be paid in US dollars, and there won't no question of exchange will arise.
As I understand, what the law, what's being relied on by Mr. Shaneen or by my opposition, is that for international contracts, you can refer to USD, for example, as the denomination to pay. You don't have to, but you can. Whereas for national contracts or domestic contracts, you can't. You must use the domestic currency.
I understood it to be the contrary, and I understood Mr. Shaheen's evidence to be, and you correct me if I'm wrong, I understood his evidence to be that if the contract is denominated in US dollars, so that it's an international contract and there is an obligation to pay in US dollars, then the court will order that obligation to be performed in US dollars. So that, but have I misunderstood?
The current prevailing rate, and the current prevailing rate in Lebanon is what's important, and the current prevailing rate. That's what it's.
I'm sorry, Ms. Malik, but that doesn't make any sense to me, because if it's paid in US dollars, there is no rate. It's paid in US dollars.
If it's paid in US dollars,
the rate would only apply if the amount is paid in Lebanese pounds.
Correct, that's correct. But my understanding, and again, I stand to be corrected, is what his opinion says is that for international contracts, or his theory is that it can be paid in USD.
I'm afraid I'm going to have to correct you then, because that's not what he says. He says it must be paid in accordance with the provisions of the contract. And that's what the authority says.
I think he talks about current prevailing rates.
Well, if it's paid in US dollars, no question of a rate arises.
Correct, I agree with that.
Well, then I don't understand the point, I'm afraid.
Well, Your Honour, I'm going to leave that there. The point is made in terms of. Okay, I'll leave that there for my later. And I'm grateful if I can assist you further. No, unless there's anything you want to hear on.
No, thank you for your submissions. Mr. Montague-Smith, in reply.
Thank you very much. Very briefly, just first dealing with the question of exclusivity or not. My learned friend made reference to the intentions of the parties, but ultimately when it comes down to is that she's making assertions, or one of the parties is making assertions of their own subjective intention. There's no evidence of anything crossing the line into things said, which could give rise to, and where would that take you anyway? It would take you to a claim for rectification, because ultimately you've got to look at the language of the clause. On the test for exclusivity, non-exclusivity, my learned friend suggested that the authorities are not settled and there's academic debate. I'm afraid that is wholly to mispresent the law on this. That when you get it, you will see the passage from Dicey that she refers to, and it's paragraph 12.105. And what it actually says in the middle of that paragraph is, the true question is whether on proper construction, the clause obliges the party to resort to the relevant jurisdiction, irrespective of whether the word exclusive is used. Footnote 507, which is what's referred to there, produces then a very long list of cases where that statement has been accepted as accurate in English law. It's only later that the Dicey goes on to talk about this distinction between transitive obligations and intransitive obligations. In other words, whether or not the parties have agreed that they shall refer a dispute, or whether they submit themselves. But there is no, what the author is actually saying is that whereas previously it was thought there might be some distinction between those two situations, such as the latter situation where the parties agree to submit themselves might not give rise to an exclusive clause, that distinction actually isn't a real one. So it's broadening the category of cases which count as exclusive. there's never been any dispute that where there is a transitive obligation that on the parties, that is an obligation to refer a dispute to a particular court, there's never been any debate in the authorities that that amounts to an exclusive jurisdiction agreement. And actually, if you read on in Joseph, which is the textbook that I took, Your Honour, and I apologise for background noise, but if you read on in Joseph, you'll see that his commentary gets to exactly the same place. In relation, I mean, ultimately, there are two issues when you're dealing with exclusivity. What is the test, and is that test satisfied? And my learned friend doesn't really have anything to say on either of them. The test is, have the parties agreed that they are each obliged to do this, to refer the dispute to Beirut? And there's no real argument taken with that. We have all this stuff about transitive and untransitive, but there can be no debate that that's the test. And then the only next question is that what the clause does when it says the parties shall do this? Those are the two short questions. It was suggested that it was never raised by the defendants that this was an exclusive clause. You'll see that there's absolutely nothing in that. I'll give you the reference, page 10, paragraph 23, where in the evidence, the defendants say that this claim has been brought in breach of a jurisdiction agreement. So the substance of the debate appears to be going back to complaining about the lack of the word exclusive. But I thought my learned friend had accepted that that word is not required. So it has always been the case that we have said that this claim is brought in breach of a jurisdiction agreement, and that means that there is a breach of an obligation to bring the claim somewhere else. In terms of underlying jurisdiction, I'm not going to labour this too much. Actually, I'll come back to that if I can. I'll go on to the good reasons for not applying the jurisdiction agreement. First, my learned friend says that Your Honour doesn't require expert evidence on these issues. You can just decide that the Lebanese courts are dysfunctional. That's a pretty outlandish submission, in my respectful submission. Then it said Donoghue and Armco itself says you can rely on. There's this point about forum non-conveniens considerations.
Yes.
My own friend took you to the passage in Donoghue and Armco where it says these are some of the things that you can take into account in deciding whether to enforce a jurisdiction agreement. What that ignores, as I pointed out in my submissions, is what came next. There's a mass of authority that comes next, and there's no suggestion that the law froze at that point. And I've taken you to plenty of authority, and again, my learned friend's own authority submitted last night or this morning supports that. And I'll refer you there if you want to, when you come to see her dicey passage, to paragraph 12, 149. But anyway, I had thought in her submissions, my learned friend had accepted that it was only unforeseeable factors which could be relied on. So all this stuff about where the contract was negotiated, where the documents might be present, where witnesses might be, even if they were right, and I don't accept that, they're all completely irrelevant. On the expert evidence, my learned friend says, well, when Mr. Malouf says he works as of counsel, he's nevertheless totally independent. I find that to be a surprising submission. Your Honour can yourself go onto the firm's website and you will see there are 8 lawyers listed there. One of them is Mr. Malouf. 5 of them are of counsel. The firm is mostly comprised of counsel. To suggest that he's totally independent is, I'm afraid, difficult to credit. We now have the submission that if you allow Mr. Malouf's evidence, the substance of the complaint is both delay and the quality of justice. As to delay, you've got the point that there is nothing specific, at least in Mr. Malouf's report, saying this is how long this claim is likely to last. As to quality of justice, you were taken to one paragraph of his report and a sentence of it, but not the whole of that sentence. If you go to page 702 of the bundle, we'll just see what the rest of that sentence says. The question was, where's the evidence that there's actual problems with the quality of justice as opposed to delay? Answer is in paragraph 37. All of the circumstances and reasons, and it's the last bit, which constitutes a real threat to justice in Lebanon. That's what you were taken to, but you weren't shown the next bit, which says, especially by extending the duration of trials without end. So it's a complaint about delay. If that's enough to say you should disregard a jurisdiction agreement, then I'm afraid you'll never enforce another jurisdiction agreement in this court. Essentially, what you're being asked to do is to infer the conclusion from various facts that the quality of justice in the Beirut courts has fallen. That, with respect, is not permissible. My learned friend needs positive, specific evidence. As to interference, it's not simply a question of foreseeability. There just is no case, because what is effectively being said is that it's amenable to interference. It's not being said there's a risk of interference in this case. My clients are not politicians. So if there's political interference, what's that got to do with us? On the question of international or not, the cassation decisions, I'll give you the references to them. They're referred to in the footnote, as I mentioned, of Mr. H. Shaheen's report, but you'll find them in particular at paragraphs, pages 557 and 566 of the bundle, and both.
So 557 and.
Sorry, 557 and 566.
566, thank you.
That's where the particular passages are within those judgments, which say in the court of cassation you have to pay. So one was in I think French francs, and the answer of the court was you have to pay in French francs. So you've also got
that's a pretty old decision then.
Sorry, it's not French francs. Sorry, it's it may be Cameroonian francs. It's a North African French country. I'm sorry. Yeah, that's right. Yeah, they are fairly old decisions. They come well before 2019. And you can see that from the footnote and paragraph in footnote 83 of the report. But you're absolutely right to pick me up on that. I can have a quick look. Actually.
Oh, it doesn't matter. I was just being cheeky at the end of a long day.
It's a long day for you. We've not quite got to breakfast over here, so that's my excuse anyway. On the service point, sorry, I'll come back now to the question of underlying jurisdiction. So first, it's now being said that the contract was actually concluded in the DIFC, in the sense that there was an agreement on all of the issues. Now, either that's a binding contract or it's not. I hadn't understood that we were being sued on the basis of any kind of agreement that was reached at a meeting, and indeed that's not the case that's put. So if you look at the claim form and the particulars of claim, both are based on the written document.
I think the argument, as I understand it, and Ms. Malik can correct me if I'm wrong, I think the argument goes this way, that when you go to 5A1C or whatever it is, the relevant provision, the gateway, it talks about wholly or partly concluded. And then you go to Karafi, and Karafi says concluded can mean the conclusion of negotiations, not necessarily the execution of the written instrument. So the argument is that the conclusion of negotiations, which led to what you might call agreement in principle, subject to execution of the document, took place at a meeting in the DIFC, and that is sufficient to satisfy the gateway, even though execution occurred later outside the DIFC. That's the argument, as
I see that, and I think that that's a question. You're bound by Karafi. That's a question of interpretation of what Karafi says. What I say Karafi says is that the reason why jurisdiction was found in that place was because the contract was negotiated in the DIFC, not because there was some event whereby the finalized version that became the executed document, the agreement, was agreed in the DIFC. So it's not about, as I understand Karafi, the point was that everything, all of the negotiations flowed through the DIFC entity. So all the documents that were being negotiated passed from Switzerland to DIFC and out to Dubai and back again. Or I think it might have been Qatar, I can't recall. But anyway, they all passed through. And so that was the basis for the decision there. I say that's wrong, but I have to take that up with someone else. But nevertheless, the point in Karafi does not go anywhere near as far as saying that one meeting, and we do say it's one meeting that you can be confident of, took place in the DIFC. Now, what we do accept that there was that one meeting, but that meeting was negotiations between lawyers. So one has to just recall, save for this dispute about the meeting at the beginning of the exercise back in April 2018, neither party is actually setting foot in the DIFC for this process. They're sending their lawyers to an office to talk about this contract. And so, you know, the question is it enough that one of the party's lawyers is effectively in the DIFC? Is that going to be sufficient to attract DIFC jurisdiction? It's not a situation where you've got the parties in the DIFC, but also it's only, we say, one instance. There's some submission about the 23rd of April 2018 meeting. You'll recall there was a dispute about what happened at that. Now, as at the out, just to take you through the chronology of this, at the outset of these proceedings, that was presented as being part of the negotiation of this document. So it was basically being said that the claimant went into the DIFC in April to negotiate the contract. That was his evidence. And then it's now appears to be accepted that that was not the case. My learned friend says, oh, well, Mr. Fadi Ghanem's evidence is that this had nothing to do with the contract. He didn't say that. He said it had nothing to do with the negotiation of this agreement. And that is, as I understand it, now completely accepted. It wasn't the negotiation of the agreement. It plainly was not. What the claimant was saying, and this is how it happened, was that he asked Mr. El Tamimi for advice. Mr. El Tamimi gave him that informal advice. Now, Al Tamimi and company were never instructed in relation to giving that advice. It was a freebie done as a favour. That's the evidence that you see. Then what happens is after that, in June, after the April meeting in June, you see Al Tamimi become instructed. Al Tamimi are not instructed by the defence before that. And the claimant was fully aware of that. And we can see that from the email at page 651 of the bundle. And it's not right. My learned friend characterises what happened then as the claimant approaching Mr. Al Tamimi and saying, how can you act because you've given me advice? That's absolutely not accurate. He says, can I just check that Mr. Ghanem is one of yours because I want to meet with him to talk about this? So he's aware at all times. And we have this by sidewind. We have this professional conduct complaint that's being raised. And I do have to say that that is not an appropriate way to deal with that. It's completely irrelevant to the arguments that you have to consider. But if my learned friend wants to make a professional conduct complaint against my client, she can do so in the proper way. And the response will be, well, if her client had a problem with Mr. Essam Al Tamimi being involved in this, why did he ask him to be involved in it in the latter part of the negotiations? So there's no question of conflict of interest. That arises where you have confidential information. There's no allegation of that sort. And there's clearly informed consent. But I'm not going to say any more about that sort of allegation because it's a serious allegation, one of professional conduct, which shouldn't have been raised in that way. But the upshot for the purposes of underlying jurisdiction is that that is a meeting, the first one at the beginning, where the claimant consulted a lawyer in the DIFC. That is it. Then that on any view is insufficient and irrelevant to the question of whether the court has jurisdiction. What the question is, what actual negotiations took place and were they in the DIFC? And I say that the threshold has to be something more than just the single meeting that you're faced with. In terms of, finally, in terms of service, I just don't understand the position on this. And I do, if I may, just show you again the documents that my learned friend relies on in relation to this. If we just go quickly to page 87 of the bundle.
Yes.
So what you can see there, this is the website that's relied on. And you can see very clearly the entity is international. It's not PTE or PDE, it's international versus partners. So this is the website of international that's relied on. Then 89, you get the actual government listing of the company, which is Partners, which is at a different address. And then they say, well, we relied on what they say, that is Khatib and Alami, in their LinkedIn on page 95. But that's not us. That's another entity. It's a different entity entirely. You can see that from the website listing on page 95 itself, which takes you back to the website that they relied on in the first place. So they've just served it at the wrong address. In terms of service in Lebanon, the question of whether it's adequate is in one sense a question of DIFC law. And what you have to do to make it valid under DIFC law is in Rule 953, you have to serve it in accordance with the rules of the place where you're serving it. And so what that can't mean is you have to serve it in accordance with the rules for service out. It just doesn't make any sense. You have to serve it in accordance with the rules for service in that jurisdiction, and they clearly haven't done that. So unless you've got any further questions, those are my submissions and response.
No, thank you, Mr. Montague-Smith. Nothing. All right. Well, that concludes the hearing then. I'm grateful to both counsel for their assistance. The arguments were well presented and very helpful to me, for which I'm most grateful. I'll obviously need to consider those arguments at some length, because the issues are clearly very important to these parties, but there are also issues which can have implications in other cases as well, because these sort of issues arise, unfortunately, far too frequently in the DIFC court. And so I need to make sure I get it right. Sorry, somebody speaking?
Sorry, my mic's on.
Right, all right. So I will reserve my decision for that purpose, and I'll publish it as soon as I can. And thank you all for your assistance, because I'm sure there are people off screen who've assisted you in the preparation of your efforts as well. So thank you to everybody concerned. Well, that concludes the hearing.
I was looking for references to page numbers. I'm just going to give them to you when I was referring to emails. They're 193 and 194. And the email that my learned friend has just referred to, and we also refer to for 11th of June, is 651. Just so you've got those. I'm grateful.
Thank you, Malik. Thank you. That's very helpful. All right. Well, that concludes the hearing. Thank you for your assistance. I'll give my decision as soon as I can. Thank you, everybody. Goodbye.